There is a Vijnaneshwara Pratisthana Trust founded by His Lordship Justice M. Rama Jois, where several legal luminaries, including the then Honorable Chief Justice of India and various judges of the Supreme Court and various high courts, several senior advocates and other members of the society have contributed, and a large and huge beautiful research center is built in Martur in Kalaburagi district of Karnataka state, which is around 15 to 20 kilometers from Kalaburagi. The awareness about this research center is much needed to be made amongst all members of the legal fraternity, so that the members of the legal fraternity can avail this opportunity and do research in Mitakshara law and its relevance in the present legal era.
Sir, Amit sir, shuru madbodi formal ಆಗಿ
Since the time is 5:54 now, I take the opportunity. May I request Ms. Ragini to yes. ನಾನು ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ, ವಿಶ್ವಸ್ತ ಹಾಗೂ ಕಾರ್ಯಕ್ರಮದ ಸಂಯೋಜಕ. ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರಗಳು. ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರು, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ವತಿಯಿಂದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ರಾಮ ಜೋಯಿಸ್ ರವರ 93ನೇ ಹುಟ್ಟುಹಬ್ಬವನ್ನು ಆನ್ಲೈನ್ ನಲ್ಲಿ 5 ಸರಣಿ ಉಪನ್ಯಾಸಗಳು 26, 27, 28 ಜುಲೈ ಹಾಗೂ 3 ಮತ್ತು 7 ಆಗಸ್ಟ್ ಮೂಲಕ ಆಚರಿಸುತ್ತಿದ್ದೇವೆ. ಉಪನ್ಯಾಸಗಳು 26, 27, 28 ಜುಲೈ ಮತ್ತು ಆಗಸ್ಟ್ 3 ಹಾಗೂ ಆಗಸ್ಟ್ 7 ರಂದು ನಡೆಯಲಿವೆ. ಡಾಕ್ಟರ್ ಎಂ ರಾಮ ಜೋಯಿಸ್ ರವರು ಸರಳ ಸಜ್ಜನಿಕೆಯ ಸಾಕಾರ ಮೂರ್ತಿ. ಸಮಾಜದಲ್ಲಿನ ಬಡವರ ಬಗ್ಗೆ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪಂಗಡಗಳ ಬಗ್ಗೆ ಅಪಾರ ಕಾಳಜಿಯುಳ್ಳವರು. ಭಾರತೀಯ ನ್ಯಾಯಶಾಸ್ತ್ರ ಕುರಿತು ಆಳವಾದ ಅಧ್ಯಯನ ಮಾಡಿದವರು. ರಿಲಿಜನ್ ಮತ್ತು ಧರ್ಮದಲ್ಲಿನ ವ್ಯತ್ಯಾಸ ಭಾರತೀಯರಿಗೆ ಮನಗಾಣಿಸಿದರು. ಮೇರು ವ್ಯಕ್ತಿತ್ವದ ನ್ಯಾಯಮೂರ್ತಿಗಳ ವಿಚಾರಗಳನ್ನು ಸಮಾಜದ ಕಟ್ಟಕಡೆಯ ವ್ಯಕ್ತಿಗೆ ಮತ್ತು ಯುವ ಪೀಳಿಗೆಗೆ ತಲುಪಿಸುವ ಸಾಧನವನ್ನಾಗಿ ಅವರ ಜನ್ಮದಿನದ ಅರ್ಥಪೂರ್ಣ ಆಚರಣೆ ಆಯೋಜಿಸಲಾಗಿದೆ. ಸಂತೃಪ್ತ ಮತ್ತು ಸಮೃದ್ಧ ಪಾರಿವಾರಿಕ ಜೀವನ ನಡೆಸಿದವರು. ಅವರ ಜನ್ಮದಿನದ ಸಂದರ್ಭದಲ್ಲಿ ಅವರಿಗೆ ಪ್ರಿಯವಾದ ಭಾರತೀಯ ಕಾನೂನು ಶಾಸ್ತ್ರ ಜೊತೆಗೆ ಪ್ರಸ್ತುತ ಕಾನೂನು ಅಧ್ಯಯನ ಕುರಿತಂತೆ ತಜ್ಞರಿಂದ ಉಪನ್ಯಾಸಗಳನ್ನು ಏರ್ಪಡಿಸಲಾಗಿದೆ. ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಇಂದು ಉಪನ್ಯಾಸ ನೀಡಲು ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಶ್ರೀ R.D. ಹುದ್ದಾರ್ ಮತ್ತು ಅಧ್ಯಕ್ಷತೆ ವಹಿಸಲಿರುವ ಶ್ರೀ ಡಾಕ್ಟರ್ ಸಿ ಬಸವರಾಜು, ಆನರಬಲ್ ವೈಸ್ ಚಾನ್ಸಲರ್ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಲಾ ಯೂನಿವರ್ಸಿಟಿ ಹುಬ್ಬಳ್ಳಿ, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಕುಲಪತಿಗಳು ಹಾಗೂ ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳು, ನ್ಯಾಯಮೂರ್ತಿ ಎಂ ರಾಮ ಜೋಯಿಸ್ ರವರ ಪರಿವಾರದ ಅಭಿಮಾನಿಗಳಾದ ಬಳಗದ ಸದಸ್ಯರು, ವಿಶ್ರಾಂತ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರು ಮತ್ತು ಪ್ರತಿಷ್ಠಾನದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ ರವರು, ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ಹಿರಿಯ ವಿಶ್ವಸ್ತರು, ಉಪನ್ಯಾಸ ಸರಣಿಗಳ ಪ್ರೇರಕರಾದ ಶ್ರೀ ಮಹಾದೇವಯ್ಯ ಕರ್ದಳ್ಳಿ ಅವರು, ಶ್ರೀ ಸುರೇಶ್ ಬುಲ್ಬುಲೆ ಅವರು, ವಿಶ್ರಾಂತ IAS ಅಧಿಕಾರಿಗಳಾದ ಶ್ರೀ ಎಂ ಲಕ್ಷ್ಮೀನಾರಾಯಣ್ ರವರು, ಮರ್ತೂರಿನ ಶ್ರೀ ಗುಂಡಪ್ಪ ಕಂಬಾರ್, ಡಾಕ್ಟರ್ ವಾಸುದೇವ್ ಸೇಡಂ ರವರು, ಬೆಂಗಳೂರಿನ ನ್ಯಾಯವಾದಿಗಳಾದ ವಿಕ್ರಮ್ ಫಡ್ಕೆ ಅವರು, ತುಮಕೂರು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಪ್ರೊಫೆಸರ್ ಎಂ ಕೊಟ್ರೇಶ್ ರವರು, ಮರ್ತೂರಿನ ಡಾಕ್ಟರ್ ಬಸವರಾಜ್ ಪಾಟೀಲ್, ಶ್ರೀ ಯೋಗೇಶ್ವರ ಯಾಜ್ಞವಲ್ಕ್ಯ ಸಮಿತಿ ಅಧ್ಯಕ್ಷರು, ಕಾರ್ಯಕ್ರಮದ ಸಂಯೋಜಕರಾದ ಶ್ರೀ SC ಪಾಟೀಲ್ ರವರು ಮತ್ತು ಶ್ರೀ ಬಸವರಾಜ್ ಗುಬ್ಬಕಡ್ಡಿ ಅವರು, ಡೀನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಫ್ ಲಾ, ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ಆಫ್ ಕರ್ನಾಟಕ ಕಡಗಂಚಿ ಕಲಬುರಗಿ, ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಮಾನ್ಯ ಕುಲಪತಿಗಳು, ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರು, ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯ ಮತ್ತು ಅನ್ಯಾನ್ಯ ಮಹಾವಿದ್ಯಾಲಯಗಳ ಪ್ರಾಚಾರ್ಯರು, ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳು ಹಾಗೂ ನ್ಯಾಯವಾದಿಗಳು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಸೇರಲಿದ್ದಾರೆ. ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಿದ್ದಾರೆ. ಅವರೆಲ್ಲರಿಗೂ ಸುಸ್ವಾಗತ. ನಮಸ್ಕಾರ. ಇಂದಿನ ನಮ್ಮ ಕಾರ್ಯಕ್ರಮದ ಅತಿಥಿ ಉಪನ್ಯಾಸಕರನ್ನು ಮತ್ತು ಅಧ್ಯಕ್ಷರನ್ನು ಪರಿಚಯ ಮಾಡಿಸಿ ಸ್ವಾಗತಿಸಲು ಡಾಕ್ಟರ್ ಎಸ್ ಚಂದ್ರಶೇಖರ್, ಪ್ರಾಂಶುಪಾಲರು, PES ಸೊಸೈಟಿ, ಸಿದ್ಧಾರ್ಥ ಲಾ ಕಾಲೇಜ್, ಕಲಬುರಗಿ ಅವರನ್ನು ಆಮಂತ್ರಿಸುತ್ತೇನೆ. ಡಾಕ್ಟರ್ ಚಂದ್ರಶೇಖರ್.
ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. All of you very good morning. It is a great honor and privilege to me to welcome today's August gathering for Justice Dr. Rama Jois Memorial Online Lecture Series 2023. See, we already know that we are commemorating a 93 birthday anniversary of legal luminaries Justice Dr. M. Rama Jois, former Chief Justice of Punjab and Haryana High Court, former Governor of Bihar, former Rajya Sabha member, and founder president of Vijnaneshwara Pratisthana Trust, Martur. And law is not a static, it is a dynamic one. In this background, today's topic is relevant, that is amendment to section 6 of the Hindu Succession Act 1956. So it is a privilege for me to introduce today's resource person, Honorable Mr. Justice Ramchandra D. Huddar. Sir is born in 13/8/1963, native of Gokak, Belgaum district, graduated in law from RL Law College, Belgaumi, enrolled as an advocate and practiced at Gokak, appointed as a municip on 8/2/1995, appointed as a district judge 2/7/2009, served as a registrar, review and statistics, registrar, administration, additional registrar general, Dharwad bench, registrar, infrastructure and maintenance, and registrar, computers, served as a principal, district and session judge, Dharwad and Mysore, worked as a director, Karnataka Judicial Academy, Bengaluru, served also as a principal, city, civil and session judge, Bengaluru, and served as an additional judge of the High Court of Karnataka on 24/1/2023. Sir, on behalf of Vijnaneshwara Pratisthana Trust, Martur, Central University of Karnataka, Kadaganchi, and Karnataka State Law University, Hubli, on behalf of all, I welcome you, sir. Thank you, sir. For this session, the President is our beloved Vice Chancellor of Karnataka State Law University, Hubli, Professor Dr. K. Basavaraju. So, introduce the sir, it is a arduous job because he touched all the field and enormous experience in administrative and academic field. But I will try my level best to introduce the sir in brief. So, Professor Dr. C. Basavaraju is presently working as a Vice Chancellor in the Karnataka State Law University, Hubli. He was also ex-Vice Chancellor, in charge Vice Chancellor, former Registrar, Syndicate member, Academic Council, member in the University of Mysore, and former Evaluation, Karnataka State, Dr. Gangubai Hangal, Music and Performing Arts University, Mysore. Having considered his academic credential, he has been nominated as a member of a National Assessment Accreditation Council as a peer team, Bengaluru, and he visited more than 15 universities and 25 colleges. And sir is a law teacher known for his commitment, honesty, integrity, and dedication in his professions. He contributed in the legal field, that is 125 research papers in both national and international academic journals. He has published 4 books and also 175 research papers in national and international seminars. His PhD thesis has been published in the form of book by the Serial Publications, New Delhi. And sir has visited abroad also for the purpose of national and international seminars. On invitation to visited Jagiellon University, Krakow, Poland, and presented his research papers in the International Conference on Environment Best Practices in India and Role of a Judiciary, for which he was awarded as a Best Paper Presented Award. He also visited Supreme Court of Bhutan and held deliberations with the Justice of the High Court and Supreme Court of Bhutan. He has visited Dubai and presented a paper on the role of a higher and its different perspective of contemporary issues at an international conference conducted by the South Asian countries organized by the Angelia Ruskin University, United Kingdom. He has also presented a paper on the role of higher education in promoting the good society at the University of Wangai, China. And is a committed professor, a teacher, a chairman, dean, a faculty. He produced successfully 18 PhD candidates, and present 8 PhD students are working under his guidance. He also adjudicated more than 95 PhD theses of various universities in India. He has organized many national seminars on human rights issues, information technology, and national integrations. And the another very important sir's profile, if I check it, that one, sir has framed the syllabus of 50 courses for the introduction of a 5 integrated programs of law in the University of Mysore. He also framed the syllabus for 40 courses for the introduction of LLM program at the University of Pondicherry, a central university, as well as the Mangalore University. The sir has received Yashashvi Sadhana Award 2011, Best Citizen of India Award 2012, National Integration Award 2015, and RTI Awareness Award 2015. Sir, if I left, sorry for that one, I cannot cover all the things. Sir, on behalf of Vijnaneshwara Pratisthana Trust, on behalf of Central University of Karnataka, Kadaganchi, on behalf of Karnataka State Law Institute, Hubli, on behalf of all, I welcome you, sir. And the lecture series, the main behind force to conduct of this lecture series, we cannot forget Shri Baswaraj S. Patil Sedam, sir, President of Vijnaneshwara Pratisthana Trust, Martur. Sir, on behalf of all, I welcome you, sir. I welcome Honorable Judges, Dean, Chairman of Law Department, Principal of all law colleges, lecturers, and dignitaries in various fields. I welcome all the students community from CUK, KSLU, and Karnataka Law College students. I welcome all, especially I thank to the Madhavya Martur sir, giving me that responsibility to welcome all the people. Sir, once again, I welcome. And also I cannot forget all the Vijnaneshwara Trust members, especially I thank to the coordinators of this lecture series, Dr. Baswaraj M. Kubkaddi, Associate Professor and Head of Department of Law, Central University, Karnataka, Amit Kumar Deshpande, Senior Advocate, High Court of Karnataka, Trustees, Vijnaneshwara Pratisthana Trust, S.C. Patil, Trustee, Vijnaneshwara Pratisthana Trust. Sir, once again, I welcome you, all of you. Thank you, and all.
ಧನ್ಯವಾದಗಳು ಶ್ರೀ ಡಾಕ್ಟರ್ ಎಸ್ ಚಂದ್ರಶೇಖರ್ ಅವರು. It's a pleasure to see Chief Justice Anand Bhairareddy, former judge of the Honorable High Court of Karnataka, also participating in this lecture. This only is another indication that all of us are always a student in our life. Welcome you also, sir. ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಮುಖ್ಯ ಭಾಷಣಕಾರರಾಗಿ ಆಗಮಿಸಿದ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ಆರ್.ಡಿ. ಹುದ್ದಾರ್, ಜಡ್ಜ್ ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ, ತಮ್ಮ ಉಪನ್ಯಾಸ ನೀಡಬೇಕೆಂದು ವಿನಂತಿಸುತ್ತೇನೆ. ಸರ್, ಓವರ್ ಟು ಯು, ಸರ್, ಪ್ಲೀಸ್.
Good evening to all. First of all, I extend my thanks to the organizers of this lecture series online for having invited me and have given an opportunity to share a few thoughts with regard to the subject which is being slated today, that is Section 6 of the Hindu Succession Act 1956. As you all know, the Hindu Succession Act 1956 was enacted so as to give protection to the women. If we see the status of a woman in India, if you go to the medieval period, it starts with the entry of the Muslims invaders in India. The span of this medieval period was about 500 years. From the era of Delhi Sultan to the Mughal era. So this, in the Indian history, if you read the Indian history, this medieval age is considered to be the dark age for women, when many foreign conquests have took place, which resulted in a decline in the women's status. So amongst that, during the medieval period, very few names of women are found in the period who became the ruler and showed their talents in various fields. To give an example of that, one is Rajya Sultan, who occupied the throne of Delhi. Some other women, Gulbandan Begum, Noor Jahan, Jahan Ara, Mumtaz Mahal, became famous because of their intellectual talents. And there was active participation of these women in the state affairs also. The Gulbadan Begum passed the poetic talent, which can be seen in the Humayun Nama, which she is the author of that document. Noor Jahan was a famous Muslim queen of Mughal India, who was a combination of beauty and bravery. Another was Mumtaz Mahal, the queen of Shah Jahan, who was a rare example of beauty and brain with ascetic state. So like this, we find this history of our medieval India has some women with heroic deeds. You must have heard the name of Chand Bibi as a savior of a fort of Ahmednagar. Tarabai, who resisted the onslaught of Aurangzeb. Mangamal, the green memory of South India. Ahalyabai Holkar, the genius administrator, or some examples of the bravery. So these Mughal princes like Jahan Hara, Roshan Hara, Jabunisa, who were the poetists, played their active role. So most of the princes or daughters of high officials were skilled in art, painting, poetry, etc. Even the history also says that Rajput princesses were also given proper knowledge of administration, art, archery, poetry, politics, etc. Amongst them, we find the name of Rani Padmavati, Jodhabai, and they are the famous names in the medieval period. The daughter of Shah Jahan, Jahan Ara, was an excellent in poetry. So, however, this medieval period was considered as a dark age. If you go to ancient history of this Indian society, as you all know, the Indian society, Hindu society was a patriarchal, which gives you the autonomy to male dominance. The state of women started failing with the arrival of Muslims when various customs were imposed on women, like sati pratha, child marriage, widow remarriage, etc. So the Indian women were considered inferior to men in this medieval period, not only physical but also mentally also. So they were denied to study Vedas and could not go for higher studies. Although there are some instances that court ladies and queens maids were able to compose a very good Sanskrit and Prakriti verses. As you all know, according to the famous Indian philosopher Vatsyayana, A woman should be expert in cooking, spinning, grinding, knowledge of medicine, recitation, and many more. Even in Buddhism, Jainism, and Christians, there was some liberal view on women's education, as they do not consider gender in uniting with the God. According to Huyan San, a Chinese traveler, Sangamitra, the daughter of King Ashoka, Rajasri, the sister of Raja Harshavardhan, were the famous scholars at that time. So this is how it was developed. Even in Tulsidas, the sloka in Tulsidas, it says with regard to the women, the plight of women can be imagined as per the sloka. That is, he writes, Dhol, Gawar, Shudra, Pashu, Nari, e sab tadan ke adhikari. That means the animals, illiterates, lower caste, and women should be subjected to beating. The child brides were denied all social interactions, including their intellectuals, physical and spiritual development. So one more reason for the decline of women's status and freedom was that original Indian wanted to shield their women folk from the barbarous Muslim invaders. Love and intercaste marriages were not allowed at the time. In the case of the girl's father, could not find a suitable groom for his daughter, then she was allowed to marry with her own while living with her father after attaining puberty. Sometimes girls were permitted to opt Swayamvara at that time. Women were dependent on male members of their family. If the husband deserts, impotent, or died, women were allowed to remarry. If husband abandoned even a guilty wife, the woman will get maintenance. So these were the developments took place gradually. Even there was a tradition of polygamy as Muslims followed. So the legislature thought of enacting the law. That is the first enactment which came into force with regard to the women was the Hindus Widows Remarriage Act 1856. Then the first act which gives the protection to the women was Hindu Inheritance Removal of Disability Act 1928. This was the first enactment which has given some protection to the women. Thereafter, as the legislature could not have not satisfied with the said rights being given, then another act came into it was enacted called as Hindu Law of Inheritance Amendment Act 1929. Thereafter, even there was some agitation with regard to the women, rights of the status of women in those days. Therefore, the next act was the Hindu Women's Right to Property Act 1937. So because of this act, certain rights were given and the status of the women were recognized. Then, inheritance under traditional Hindu law was also came into existence. Thereafter, the act was Hindu Succession Act 1956. So one of the most significant ideas behind the evolution of the family was to provide security to the members of the family. An undivided Hindu family is ordinarily joint, as you all know, not only in estate but also in the food and worship. So the joint family system comes first and law of inheritance is of a later growth. So therefore, the Hindu Succession Act 1956, as you all know, gives certain right over the property to the woman, being the daughters. There, the notional partition was recognized. And in the father's property, the daughter was held entitled for share in the property in question. So even under the provisions of the Hindu law, the preference was given to the first-class females who had a limited right over the property in question as per 1937 Act. So that in view of section 14.1 and 14.2 of the Hindu Succession Act, so amended, so came into existence in the 1956. Whatever the limited right which was given to the woman was enlarged into absolute estate. That was the position of law. And therefore, if you read the provisions of the Hindu Succession Act, even the provisions of the earlier act like Hindu Inheritance Removal of Disability Act 1928, the Hindu Law of Inheritance Amendment Act 1929, the Hindu Women's Right to Property Act 1937, and even inheritance under traditional Hindu law. The woman, the daughter was, the daughter, though not a co-partner under the traditional Hindu law, that is Mitakshara law, but is made as a co-partner under the progressive enactments to meet gender equality as enshrined in the Indian Constitution. Therefore, our Constitution conferred certain right to the daughter in the ancestral property in her paternal home. So, under the Hindu Succession Act, a daughter was not recognized as a co-partner. However, she was conferred with the status of a class 1 legal heir and could inherit her father's property along with other class 1 legal heirs. This we have to remember with regard to that provisions of section 6 and 8 of the Hindu Succession Act 1956. So, in 1956 Act, daughter was not a co-partner, but she was a class 1 legal heir, and by applying the doctrine of notional partition, she was held entitled for a share in the father's share. So, however, for the first time, with regard to the status of women to be given a co-partner status, the first state which amended the Hindu Succession Act was Andhra Pradesh. So, Andhra Pradesh state effected an amendment called as Hindu Succession Andhra Pradesh Amendment Act 1986, which came into force from 5/9/1985. Thereafter, as per this act, the Andhra Pradesh government conferred co-partner status to the daughter. Thereafter, the state of Tamil Nadu enacted a similar enactment called as Hindu Succession Tamil Nadu Amendment Act 1989, which came into effect from 25/3/1989. Subsequently, the similar amendment has taken place in Maharashtra called as Hindu Succession Act Maharashtra Amendment Act 1994, which came into force from 22/6/1994. So thereafter, our state, the Karnataka state, also has enacted the Hindu Succession Act Karnataka Amendment Act 1990, which came into force from 30/7/1994, whereby it inserted section 6A to 6C up to the Hindu Succession Act Karnataka Amendment. Therefore, these 4 states are the only states for the first time conferred co-partner status on a daughter and gave her an equal footing as that of a man. The dates are very much important while deciding the partition suits in a case where the daughters claim the partition. Therefore, thereafter, in the year 2005, as you all know, there was an amendment to the Hindu Succession Act. There is a central amendment to the Hindu Succession Act. The Parliament of India, much later, that is year 2005, amended section 6 of the Hindu Succession Act 1956 by way of enacting the Hindu Succession Amendment Act 2005 with effect from 9/9/2005. The dates are very important in this. So, with effect from 9/9/1995, we in the entire country is following the Hindu Succession Act. And by virtue of this act, it conferred co-partner status on daughters across India. That we have to understand. So, in a statement of objective reasons, if you read the statement of objects of the said amendment, it applauded the efforts of these 4 state legislatures, that is Karnataka, Maharashtra, Tamil Nadu, and Andhra Pradesh, which strive to drive an equality between a son and a daughter in a joint Hindu family governed by the Mitakshara school of Hindu law. Therefore, if you read the provisions of the judgment in Vinesh Sharma case, which is being reported in 2020 part 9, SCC page 1 at page number 33, the Honorable Supreme Court has appreciated the efforts of these four states, and it has stated that besides the various sources, custom, equity, justice, and conscience have also played a pivotal role in the development of Hindu law, which prevailed. When the law was silent on certain aspects, judicial decisions also acted as a source of law. Hindu law was not static, but always progressive. Slowly, necessity was felt for the codification of the Hindu law. In particular, women's rights were taken care of and attempts were made to remove the anomalies and unscrupulous practices. Necessity was also felt after the independence, given the constitutional imperatives to bring about equality of status. The codified law has been amended from time to time. The latest attempt has been made by way of amending the Hindu Section Act concerning rights of daughter to be a co-parser in withCentral School of Hindu Law. This is what the Supreme Court has observed in its judgment with regard to the co-parser rights being given to the equal right being given to the daughter as well as son. Therefore, further in the said judgment itself, in Vinesh Sharma case, as stated, on reading the provisions of Section 6 of the Hindu Succession Act, there was a discrimination in between son and daughter. And by virtue of this Amendment Act, this discrimination has been done away with, and they have been provided equal treatment in the matter of inheritance with the withCentral co-parser. See, Andhra Pradesh, Tamil Nadu, Karnataka, Maharashtra, the efforts made by these states have been appreciated. And the amendment which has taken place in Karnataka state was made on 37/1994, which came into effect from that date by insertion of Section 6A of the Karnataka Amendment Act. As we are very much concerned about this Karnataka, so we have to remember the date of this enactment, Karnataka Amendment, 1956 Amendment, as well as the 2005 Amendment. So, considering the amendment to Hindu Succession Act, 1956, we have to see that we have to make a distinction. That is, from 17/6/1956 to 29/7/1994, that is a till coming into force of the Karnataka Hindu Succession Amendment Act, Hindu Succession to amend to the Hindu Succession Act, daughter was not a co-partner under the Hindu Section 1956. That means in between 17/6 to 1956 till 29/7/1994, under the Hindu Section Act, daughter was not a co-partner. From 37/1994 till 8/9/2005, daughter was a co-partner under the Hindu Succession Act, Karnataka Amendment Act 1990. Then from 9/9/2005 till date, a daughter is a co-partner under the Hindu Succession Amendment Act 2005. Why these dates are very much important? If a suit is filed before the civil court, there the question may arise to a court that which law is applicable. If the daughter is, whether daughter is entitled to claim the right in the property of under the 1956 Act, or under the 1990 Karnataka Amendment Act, or under the provisions of the 2005 Amendment Act. So, these dates are very, very important while deciding the suits for partition, wherein the daughters have claimed their shares in the property in question. Now, as you all know, day in and day out, we experience that the suits are being filed before the civil court, claiming that the properties are joint family properties, they are the self-acquired properties, they are all the plaintiffs and defendants are tenants in common, etc. So, before deciding the said aspect, or to decide the said suit, every advocate as well as the judge must know the concept of the joint family, joint Hindu family. So, as you all know, the law students are here as well as the faculty members of the law college are there and experts are here. So a joint family consists of all persons lineally descended from a common ancestor and includes their wives and unmarried daughters. So first of all, we must know the concept of the joint Hindu family. It consists of all persons lineally descended from a common ancestor and includes their wives and unmarried daughters. Conservatively, a daughter ceases to be a member of her father's family on marriage and becomes a member of her husband's family. ನಿಮಗೆಲ್ಲ ಗೊತ್ತು, ಹೆಣ್ಮಗಳು ಮನೆಯಲ್ಲಿ ಇರೋ ತನಕ ಆ ಮನೆಯ ಒಂದು ಮೆಂಬರ್ ಆಗಿರುತ್ತಾಳೆ. ಮದುವೆ ಆದ ಮೇಲೆ she becomes a member of her husband's family. However, subsequent to the enactment of Hindu Section Act Karnataka in 1990 and also Hindu Section Act 2005, a daughter, even after her marriage, is considered to be a co-partner in her parental home for all practical purposes of succession. If it satisfies the other conditions of the enactment, which under Matra, she will be qualified as a co-partner. To know better on this aspect, with regard to the recognition of, with regard to the concept of joint Hindu family, way back in 1976, the Honorable Supreme Court in Surajit Lal Chabda versus Commissioner of Income Tax reported in 1976, Part 3 SCC, page 142, in para 13 and 14, have held with regard to the co-partnery concept. I quote, outside the limits of co-partnery, there is a fringe of persons, males and females, who constitute an undivided or joint family. There is no limit to the number of persons who can compose it, nor to their remoteness from the common ancestor and to their relationship with one another. So it says a joint Hindu family consists of persons linearly descended from a common ancestor and includes their wives and unmarried daughters on the head today. So the daughter on marriage ceases to be the member of her father's family and becomes the member of her husband's family. The joint Hindu family is thus a larger body consisting of a group of persons who are united by the tie of a sapindaship arising by birth, marriage, and adoption. This concept has to be understood by each of the learners of law. So the fundamental principle what is vested in is that under the Hindu joint family, it is a sapindaship. Without that, it is impossible to form a joint Hindu family. With it, as long as family is living together, it is almost impossible not to form a joint Hindu family. It is a family relation, the sapinda relation which distinguishes the joint family and is of the very essence. So the joint Hindu family, with all its incidents, is thus a creature of a law and cannot be created by an act of parties, except to the extent to which the stranger may be affiliated to the family by way of adoption. Adoption on bitre, ಬೇರೆ ಯಾವ ರೀತಿಯಿಂದ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಯಾರು ಅಕ್ಕಪಕ್ಕದವ್ರು ಬಂದು ನಾವು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಅಂತ ಹೇಳೋಕ್ಕಾಗಲ್ಲ. That what is the concept of this Hindu joint families? Sapindaship always plays an important role ಅಂತ. ಅದರಲ್ಲಿ ಅದಕ್ಕೆ ಈ ವಿನಿ ಶರ್ಮಾ ಕೇಸಲ್ಲಿ ಸಹಿತ ಇನ್ ಪ್ಯಾರಾ 22 ಅಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾರೆ. ಆನರಬಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೇಸ್ a joint Hindu family is a larger body than a Hindu co-partnery. A joint Hindu family consists of all persons lineally descended from a common ancestor and include their wives and unmarried daughters. A joint Hindu family is one in worship and holds joint assets. After separation of assets, the family ceases to be a joint. Mere severance in food and worship is not treated as separation. Ega, some advocates are here who are also hearing. They may file a suit stating that ಫುಡ್ ಬೇರೆ ಇತ್ತು, ವರ್ಷಿಪ್ ಬೇರೆ ಇದೆ, ಹಾಗೆ ನಾವು ಈಗಾಗಲೇ there is a severance of status ಅಂತ. But the law says that mere severance in food and worship is not treated as a separation unless there is a partition by means and bounds. Then when we understand the concept of the joint Hindu family, we also must know the concept of co-parsonary as defined under the Hindu law. So this co-parson is defined as a joint heirship or a joint ownership of a property and is a product of ancient Hindu jurisprudence, as you all know, which later on became an integral part of withCentral school of Hindu law. The conception of this joint Hindu family constituting a co-parson is that of a common male ancestor with his lineal descendants in the male line within 4 degrees, counting from and inclusive of such ancestor, or 3 degrees exclusive of the ancestor. ಈ ಕಾನ್ಸೆಪ್ಟ್ ಅನ್ನ ಪ್ರತಿಯೊಬ್ರು ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ರೆ ನಾವು ಕೋ-ಪರ್ಸನ್ ಅನ್ನು ಹೇಗೆ ಡಿಫೈನ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳ್ಬೋದು. ಯಾವಾಗಲೂ ಕಾಮನ್ ಅನ್ಸರ್ ಇರ್ತಾರೆ, ಅವರಿಂದ ಅವನ್ನ ಬಿಟ್ಟು 3 ಅಪ್ಪ, ಮಗ, ಮೊಮ್ಮಗ, ಮರಿಮಗ ಕೋ-ಪರ್ಸನ್ಸ್. ಅದರಲ್ಲಿ ಅಪ್ಪನ ಬಿಟ್ರೆ ಈ 3 ಕೋ-ಪರ್ಸನ್ ಆಗ್ತಾರೆ ಅಂತ ವಾಟ್ ದಿಸ್ ಕನ್ಸೆಪ್ಟ್. ಅದಕ್ಕೆ ದಿ ಆನರಬಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇನ್ ಸ್ಟೇಟ್ ಆಫ್ ಮಹಾರಾಷ್ಟ್ರ ವರ್ಸಸ್ ನಾರಾಯಣ ರಾವ್ ಕೇಸ್ ಅಲ್ಲಿ ಬಹಳ ಚೆನ್ನಾಗಿ ಈ ಕನ್ಸೆಪ್ಟ್ ಆಫ್ ದಿಸ್ ಕೋ-ಪರ್ಸನ್ ಅಂತ ಹೇಳ್ತಾರೆ. ದಟ್ ಈಸ್ ರಿಪೋರ್ಟೆಡ್ ಇನ್ 1985 ವಾಲ್ಯೂಮ್ 2 SEC page 321, wherein it is held that a Hindu co-parsonary is however a narrower body than the joint family. Traditionally, only males who acquire by birth an interest in the joint or co-parsonary property can be members of the co-parson and become the co-parsoners. Thus, a male member of a joint family and his sons, grandsons and great-grandsons constitute co-parsonary and what the Supreme Court has ruled. So this concept has to be understood in a proper manner. Then the judges as well as advocates can deal with such cases effectively ಅಂತ. ಯಾವಾಗ್ಲೂ ನಾವು ಏನ್ ಮಾಡ್ತೀವಿ ಅಂತಂದ್ರೆ ನಿಮ್ಗೆಲ್ಲ ಗೊತ್ತು, ಈ ಹಿಂದೂ ಸಕ್ಸೆಷನ್ ಅಲ್ಲಿ ದಿ ಶೇರ್ಸ್ ಆಲ್ವೇಸ್ ಫ್ಲಕ್ಚುಯೇಟ್ಸ್. ಯಾರಾದ್ರೂ ಮನೆಯಲ್ಲಿ ಹುಟ್ಟಿದ್ರೆ ಶೇರು ಕಡಿಮೆ ಆಗ್ತದೆ, ಯಾರಾದ್ರೂ ತೀರ್ಕೊಂಡ್ರೆ ಶೇರು ಹೆಚ್ಚಾಗ್ತದೆ. ಸೊ ದಿ ಶೇರ್ always fluctuates as it decreases by death of a co-person and decreases on the birth of a co-person. ಆ ಬಗ್ಗೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವಿನೀತ್ ಶರ್ಮಾ ಕೇಸಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಫಾರ್ ಇಂಟರ್ಪ್ರಿಟಿಂಗ್ ದಿ ಪ್ರೊವಿಷನ್ಸ್ ಆಫ್ ಸೆಕ್ಷನ್ 6 of the Hindu Succession Act, it is necessary to ponder how co-person is formed. ಯಾವುದೇ ಒಂದು ಪಾರ್ಟಿಷನ್ಸ್ ಡಿಸೈಡ್ ಮಾಡಬೇಕಾದ್ರೆ we have to understand that how the co-parsory was being formed in that particular case. The basic concept of this co-parsory is based upon common ownership of the co-parsoners. When it remains undivided, the share of the co-parson is not certain. ಯಾವುದೇ ಒಂದು ಜಾಯಿಂಟ್ ಹಿಂದೂ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಪಾಲ್ ಆಗ್ಲಿಲ್ಲ, ಪಾರ್ಟಿಷನ್ ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಆ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಯಾವ ಕೋ-ಪರ್ಸನ್ ಎಷ್ಟು ಶೇರ್ ಅಂತ ಡಿಫೈನ್ ಆಗಿರೋದಿಲ್ಲ. ಅಂದ್ರೆ ಪ್ರತಿಯೊಬ್ಬ ಕೋ-ಪರ್ಸನ್ ಹ್ಯಾವ್ ಗಾಟ್ ರೈಟ್ ಇನ್ ಈಚ್ ಇಂಚ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ. ಇಟ್ ಮೇ ಬಿ ಲ್ಯಾಂಡ್ ಪ್ರಾಪರ್ಟಿ, ಇಟ್ ಮೇ ಬಿ ಮೊಬೈಲ್ ಪ್ರಾಪರ್ಟಿ, ಇಟ್ ಮೇ ಬಿ ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ, ಎಟ್ಸೆಟ್ರಾ. ಸೊ ವೆನ್ ಇಟ್ ರಿಮೇನ್ಸ್ ಅನ್ಡಿವೈಡೆಡ್, the share of the co-parson is not certain. ಅದಕ್ಕೆ the word has been used, the partition shall be effected by means and bounds ಅಂತಾರೆ. So nobody can claim with the precision the extent of his right in the undivided property. Co-parson cannot claim any precise share as the interest in the co-parson property, which is fluctuating. It increases or diminishes by death and birth in the family. ಈಗ 4 degrees ಅಂತ ಒಂದು ಶಬ್ದ ಬಂತು. ಸಿ ವಾಟ್ ಇಸ್ ದಿಸ್ 4 degree? ದ ರೂಲ್ ಆಫ್ 4 degree ಅಂತ ಒಂದು ಹಿಂದೂ ಸೆಕ್ಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ, ಹಿಂದೂ ಸಲಾದಲ್ಲಿ ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ. ಅಂದ್ರೆ ದಿ ರೂಲ್ ಆಫ್ 4 degrees ಇಸ್ ದಟ್ every co-pursory must have a common ancestor. To start with, it is not to be supposed that every extent co-pursory is limited to 4 degrees from the common ancestor. A member of a joint Hindu family may be removed more than 4 degrees from the common ancestor, original holder, etc., and that he may be a co-purser. The concept of this co-pursory have been well discussed by the learned author Mullah in Hindu Law, 23rd edition at page number 390. So it would mean that this rule of 4 degree have to be considered. If you consider the 4 degrees, that is great-grandfather, grandfather, father, son, they would be the co-partners and can demand a partition. Either of one can demand a partition. But if the fifth line of the descent, that is, if the son's son were to born, then such a son's son can be called as a co-parser and can demand a partition only upon the death of the great-grandfather. ಅದನ್ನ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ಈ ಡಿಗ್ರೀಸ್ ಅಂದ್ರೆ ರೂಲ್ ಆಫ್ 4 degrees ಅಂತಂದ್ರೆ ಅವ 5 ಡಿಗ್ರಿ ಇದ್ರೆ ಅವನಿಗೆ ಈ ಕೆನಾಟ್ ಡಿಮಾಂಡ್ ದಿ ಪಾರ್ಟಿಷನ್ ಅನ್ಲೆಸ್ ದಿ ಫಸ್ಟ್ ಯಾರಾದ್ರೂ ಐದರ್ ಆಫ್ 3-4 ಡೈಸ್ ಇದ್ರೆ ಬರೋಲ್ಲ ಅಂತ. As such, the descent of succession would continue up to 4 generations only, no matter how far the generation goes from the original holder. So it is important and necessary that such a successive line remains within the 4 degrees of succession, and the fifth line of descent would get a right to be called co-parser and demand a partition only when his first line link dies. ಅಂದ್ರೆ ಮುತ್ತದ ಐದನೇದಾವಿದ್ರೆ ಫಸ್ಟ್ ಇದ್ದಾವ ಅಥವಾ 2-3 ತೀರ್ಕೊಂಡಾಗ ಮಾತ್ರ ಇವರಿಗೆ ಸಕ್ಸೆಷನ್ ಓಪನ್ಸ್ ಅಂತ ವಾಟ್ ಇಟ್ ಸೇಸ್. ಅದಕ್ಕೆ ಈ ವಿನಯ್ ಶರ್ಮಾ ಕೇಸಲ್ಲಿ ಇನ್ ಪ್ಯಾರಾ 34 and ಪ್ಯಾರಾ 23 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಹಿಂದೂ co-purser is a much narrower body. It consists of propositors and 3 lineal descendants. Before 2005, it included only those persons like sons, grandsons, and great-grandsons. ಈ ಹಳೆ ಹಿಂದೂ 1956 ಆಕ್ಟ್ ಅಲ್ಲಿ ಬರೀ ಮೇಲ್ ಮೆಂಬರ್ಸ್ ಇದ್ರು. ಅವ್ರ್ಯಾರಂದ್ರೆ ಸನ್ಸ್, ಗ್ರ್ಯಾಂಡ್ ಸನ್ಸ್ ಅಂಡ್ ಗ್ರೇಟ್ ಗ್ರ್ಯಾಂಡ್ ಸನ್ಸ್, ಹೂ ಆರ್ ದಿ holders of the joint family. To give an example on that, in case A is holding the property, B is his son, C is his grandson, D is his great grandson, only, and E is his great grandson. Avaga the co-pursory will be formed up to D only. A, B, C, D only. E barala. He is not a co-purser. That is, great grandson is not a co-purser. The right of E would ripen in co-purser property as a co-purser is confined to 3 lineal descendants. Since these grandsons and great-grandsons become co-pursers by birth, they acquired an interest in the property. And what this Vinay Sharma case ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. So, under the 2005 Amendment Act, it has given a co-pursory right to the co-pursers. They will get a right by birth. Another method to be co-purser is by way of adoption, as you all know. Adoption adaga he will become the member of the adopted family and ceases to be the member of the natural family. As earlier, as you know, a woman could not be a co-purser in 1956 Act, but she could still be joint family member. By substituting section 6, which is from 9/9/2005, daughters are recognized as co-partners in their rights by birth in the family like a son. That means daughter is also entitled for a share equal to that of a son, and she gets a right by way of birth. So co-purser is a creation of a law. Only a co-purser has a right to demand a partition. ಬೇರೆ ಯಾರೋ ಬಂದು ನನಗೆ ಪಾಲು ಕೊಡು ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ ಅಂತ. Test is, if a person can demand a partition, he is a co-purser, not otherwise. Great-grandsons cannot demand a partition as he is not a co-purser. In a case out of 3 male descendants, one or other has died, the last holder, even if he is a fifth man, fifth descendant, he can claim a partition. That is what has been held by the Vijnaneshwara case by the Supreme Court. Again, when we understand the concept of joint Hindu family as well as this co-parsory property, co-parsory etc., we also must know the meaning of unobstructed heritage and obstructed heritage as defined under the provisions of the Hindu law as well as Hindu Succession Act. If you read the Mithakshara school of Hindu law, Mithakshara divides property into two classes. That is unobstructed heritage and obstructed heritage. In Sanskrit, it is called as apratibandha daya or sapratibandha daya anta heltare. So what is unobstructed heritage anta now nodkondre? Property in which a person acquires a right, an interest by birth is called unobstructed heritage, because the accrual of the right to it is not obstructed by the existence of the owner. ಈಗ ಒಂದು ಮನೆಯಲ್ಲಿ ಒಬ್ಬ ಅಜ್ಜ ಇರ್ತಾನೆ, ತಂದೆ ಇರ್ತಾನೆ, ಮೊಮ್ಮಗ ಇರ್ತಾರೆ. ಅಲ್ಲಿ 3 ಜನ ಮಾತ್ರ ಇರ್ತಾರೆ. ಈ ಮೊಮ್ಮಗ ಹುಟ್ಟು ಮೊದಲು ಇವರಿಬ್ಬರೇ ಕೋಪರ್ಸಸ್, ಅಜ್ಜ ಮತ್ತು ತಂದೆ. ಇವನು ಹುಟ್ಟಿದ ತಕ್ಷಣ ಇವನಿಗೆ he will get a birthright in the property. That is called as unobstructed. There is no obstruction at all to claim the right in the property. That is, it is called as unobstructed heritage. Yavade obstruction illade, he can seek a partition. So, property inherited by Hindu from his father, father's father, father's father's father, but not from his maternal grandfather, is unobstructed heritage as regards his own male issue. So this concept has to be understood while deciding the partition source. So the male issues acquire an interest in it from the moment of their birth. The right to it arises from the mere fact of their birth in the family. This is called unobstructed heritage. Then what is obstructed heritage? The right is a property to which accrues not by birth, but on the death of a last owner, leaving a male issue, is called obstructed heritage. It is called, because of this accrual of right is obstructed because of the one owner. That means Ajja, Tande, Maga, Mammaga, Marimaga. Even 4 descent iddavaga, ee Marimammaganige, unless one of them dies, succession will not open. He will not be called as a co-parser. So what is, therefore there is an obstruction of leaving of one person being a linear descendant. If there is an obstruction to claim a right in the property, that is called as obstructed heritage. That has been well discussed by the Honorable Supreme Court in Vijnaneshwara case in para 48 and 49, wherein apratibandha daya and obstructed heritage, sapratibandha daya, when right is created by birth, is called as unobstructed. When right is created because of leaving of certain 3 descendants, 1, 2, 3 like that, then it is called as a obstructed heritage. So apparently the obstructed heritage takes place by birth, and the obstructed heritage takes place after death of the owner. So when we understand this obstructed heritage, unobstructed heritage, we also must know the meaning of property being defined under the Hindu law. So under the property under the Hindu law can be classified into 2 heads. That is, one is co-parsory property, another is separate property. So when co-parsory property concept comes, the property which consists of ancestral property, and a co-parsory would mean a person who shares equally with others in inheritance in the estate of a common ancestor, is called as a co-parsory property. ಯಾವುದೇ ಒಂದು ಆಸ್ತಿಯಲ್ಲಿ ಈ ಡಿಸೆಂಡೆಂಟ್ ಎಲ್ಲ ನಾವು ನೋಡಿದವಾಗ ಅವನಿಗೆ ಈಕ್ವಲ್ ರೈಟ್ ಇರುತ್ತದೋ ಅದಕ್ಕೆ it is called as a co-parsory property. Now daughter is also included. So co-parsory is a narrower body than the joint Hindu family. And before this Karnataka Amendment Act 1990 and the Hindu Succession Act Amendment Act 2005 came into force, only male members of the family used to acquire the birth interest in the property, in a co-person property. So this term, joint family property is synonymous with co-person property, what the Supreme Court says in this Vijnaneshwara case. So the Honorable Apex Court of India in Vijnaneshwara case in para 34 and para 24 have held that co-person property is the one which is inherited by a Hindu from his father, grandfather, or a great-grandfather. Property inherited from others is held in his rights and cannot be treated as a forming part of the co-personary anta ಹೇಳ್ತಾರೆ. So the property is a co-property, is called as a joint owners property ಅಂತ ನಾವು ಹೇಳ್ಬೋದು ಅಂತ. ಹಾಗೆ ನಾವು ಮುಂದೆ ಹೋದಾಗ ಹಿಂದೂ ಸೆಕ್ಷನ್ ಮತ್ತೆ ಹಾಗೆ ಓದ್ತಾ ಹೋದವಾಗ ಈ co-personary ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಸಹಿತ there are two classifications. That is co-personary property ಅಲ್ಲಿ ಒಂದು ancestral property ಮತ್ತೊಂದು joint family property which is not ancestral. Now while deciding the partition suit, these all have to be taken into consideration. ಅಂದ್ರೆ ಈ co-person property ಅಂತ ಪ್ಲೀಡ್ ಮಾಡಿದವಾಗ ಅದು ancestral property ಹೌದಾನ ಅಥವಾ joint family property ಹೌದಾನ ಅಂತ ನಾವು joint family property which is not ancestral ಅಂತ ನಾವು ಡಿಫೈನ್ ಮಾಡ್ಕೋಬೇಕಾಗುತ್ತೆ. There must be pleading to that effect in the respective pleadings of the parties. ಅಂದ್ರೆ ಈ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ಇಸ್ ನಾಟ್ ಎನ್ಸಿಸ್ಟ್ರಲ್, ಎನ್ಸಿಸ್ಟ್ರಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ಏನು ಅಂತ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಂಡವಾಗ ಈ ಎನ್ಸಿಸ್ಟ್ರಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂತಂದ್ರೆ ಇಟ್ ಈಸ್ ಅ ಸ್ಪೆಸೀಸ್ ಆಫ್ ಅ co-personary property. Ancestral property is acquired by unobstructed heritage. The Supreme Court of India in Shyam Narayan Prasad versus Krishna Prasad case ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, in 2018 ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಅದು. Shyam Narayan Prasad versus Krishna Prasad 2018 part 7 SCC page 646 ಅಲ್ಲಿ ancestral property as a property inherited by a male Hindu from his father, father's father or father's father's father is an ancestral property ಅಂತ ಹೇಳ್ತಾರೆ. ಅಜ್ಜನಿಂದ ಬಂದದ್ದು, ತಂದೆಯಿಂದ ಬಂದದ್ದು ಎಲ್ಲ ಏನಿದೆ ಅಲ್ಲ, that can be termed as ancestral. ಅಜ್ಜನಿಂದ ಮಗನಿಗೆ, ಮಗನಿಂದ ಮಗನಿಗೆ, ಅವನಿಗೆ ಹೀಗೆ ಬರ್ತದೆ ಅಂತ. So the essential feature of ancestral property is that according to Hindu Mitakshara law, sons, grandsons and great-grandsons of the person who inherit acquire an interest and the rights attached to such property at the moment of their birth. ಯಾರು ಹುಟ್ಟಿದ ತಕ್ಷಣ ತನ್ನ ಅಜ್ಜನ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಆಸ್ತಿಯನ್ನ ಹಕ್ಕಲ್ಲಿ ಕೇಳ್ತಾರೋ, ಹಕ್ಕು ಅವರಿಗೆ ಬರ್ತದೋ, ಅದೆಲ್ಲ ancestral property ಅಂತ ನಾವು ಕಂಡುಹಿಡಿಬಹುದು ಅಂತ. The share which a co-person obtains on partition of ancestral property is ancestral property as regards his male issues. If a Hindu inherits unobstructed heritage, that is property from his father, it becomes ancestral in the hands of his son. In such a situation, it is said that the son becomes the co-partner with the father as regards the property so inherited by him. So co-partnership consists of father and son anta helbodu anta. So however, this does not mean that the co-partnership can consist only the father, son, ibre irbekanta enilla. It is only the sons but also the grandsons and great-grandsons also acquire the interest by birth in the co-partnership property. ಅದಕ್ಕೆ ಈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು ಹೇಳ್ತಾರೆ, ಇನ್ ರೋಹಿತ್ ಚೌಹಾಣ್ ವರ್ಸಸ್ ಸುರೀಂದರ್ ಸಿಂಗ್ ಕೇಸ್ ಅಲ್ಲಿ 2013 ಪಾರ್ಟ್ 9 ಇನ್ ಪೇಜ್ ನಂಬರ್ 423 ಪ್ಯಾರಾ 11ರಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಆನ್ ಎ ಪಾರ್ಟಿಷನ್ the ancestral property comes into the hands of the individual persons, co-partners, then it has to be treated as a separate property and such a person shall be entitled to dispose of the co-person property, treated it to be his separate property. But if the son is subsequently born, the alienation made before the birth cannot be questioned. But the moment a son is born, the property still intact with such individual, then such property becomes a co-possessive property and the son would acquire an interest in that ಅಂತ ಅಂದ್ರೆ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಈ ಪಾರ್ಟಿಷನ್ ಆಗೋ ಸಂದರ್ಭದಲ್ಲಿ if the property is in the hands of the ancestor, it is called as a ಅಂದ್ರೆ ಪಾರ್ಟಿಷನ್ ಆದ ನಂತರ ಅದು ಸೆಪರೇಟ್ ಪ್ರಾಪರ್ಟಿ ಆಗಿದ್ದ ಆ ಸಂದರ್ಭದಲ್ಲಿ ಆ ಏನು ಅವನಿಗೆ ಯಾವ್ದು ಬಂದಿರ್ತದೋ ಆ ಪ್ರಾಪರ್ಟಿಯನ್ನ ಮಾರಾಟ ಮಾಡಬಹುದು, ಎಲಿನೇಟ್ ಮಾಡಬಹುದು, ಏನೋ ಮಾಡಬಹುದು ಬಿಫೋರ್ ದಿ ಬರ್ತ್ ಆಫ್ ಎ ಸನ್. ಒನ್ಸ್ ಅ ಸನ್ ಇಸ್ ಬಾರ್ನ್, ಇಟ್ ಈಸ್ ಅ co-possessive ಪ್ರಾಪರ್ಟಿ ಆಗುತ್ತೆ ಅಂತ. ಟು ಗಿವ್ ಎನ್ ಎಕ್ಸಾಂಪಲ್ ಆನ್ ದಟ್, ಈಗ ಒಂದು ಯಾವ್ದೋ ಒಂದು ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆಗ್ತದೆ. ಪಾರ್ಟಿಷನ್ ಆದ್ಮೇಲೆ ದಿ ಮಿಸ್ಟರ್ ಎ ಈ ಬಿಂಗ್ ದ ಸನ್ ಇಸ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಎ ಶೇರ್ ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡ್ತಾರೆ ಕೋರ್ಟ್ನವರು, ಆ ತರ ಪಾಲಾಗುತ್ತೆ. ಸೊ ದಿ ಎ is a married person, but no issues were born to him. As the property is being allotted to him, then he becomes the exclusive owner of the said property for which he is entitled to. And till the son is born to him, he can deal with the property like this thing. There is the spirit of the judgment of the Supreme Court in Rohit Chavan case. Once a son is born, subsequent to that alienation, if the son is born, son cannot claim any share in the property. If the son is born till the property is with his father, then the son gets a equal right in the property and he becomes a co-person. That is the spirit of this 2013 judgment. And day in day out we come across such cases before the civil courts, wherein the one of the co-person may plead that the property ನಾನು ತಗೊಂಡಿದ್ದೆ, ನಮ್ಮಪ್ಪ ಕೊಟ್ಟಿದ್ದ, ಅದು ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾನು, ಅದಕ್ಕೆ ಯಾರಿಗೂ ಹಕ್ಕಿಲ್ಲ ಅಂತ. If it is proved before the court that before the birth of a son the said alienation is made, the son is not entitled. Once the son is born, then the said alienation can be challenged by the said son by filing a suit for partition. That is what the spirit of this Rohit Chavan case. ಹಾಗೆ ತಮಗೆಲ್ಲ ಗೊತ್ತು ಪಾಪ್ಯುಲರ್ ಕೇಸ್ ಪುಷ್ಪಲತಾ ವರ್ಸಸ್ ವಿ ಪಿ ಪದ್ಮಾ ಅಂತ ಕೇಸಲ್ಲಿ, ವಿಚ್ ಇಸ್ ರಿಪೋರ್ಟೆಡ್ ಇನ್ ILR 2019 ಕರ್ನಾಟಕ page 205 ಅಲ್ಲಿ at page 3220 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ in para 21, whenever a partition of ancestral property takes place, the share that a co-possessor gets continues to be ancestral if on the date of partition he has a son. Further here that he holds such a property as his ancestral property if no son exists on the date of partition. But if a son is born subsequently, the ancestral character revives after commencement of the Hindu section of Karnataka Amendment Act 2005. The presence of the daughter or birth of a daughter subsequently has the same effect, but her entitlement to a share being a co-possessor is subject to the riders so fixed under section 6 of the Succession Act and what is held in Pushpalata case. ಅದಕ್ಕೆ the Honorable Supreme Court in Vinay Sharma case, referring the case in Sheila Devi versus Lalchan case ಅಲ್ಲಿ, ಹಾಗೆ the Supreme Court referred the judgment in Sitabai and another versus Ramachandra Dharma Shamrao Agal case ಅಲ್ಲಿ, the Supreme Court says in case co-possessory property comes to the hands of a single person, temporarily it would be treated as his property, but once a son is born, co-possessory would, in terms of Mitaksara law, would revive and what the Supreme Court says. So therefore, we have to keep in mind all these principles while deciding the partitions that were conducted in the partitions. ಹಾಗೆ ದಿ ನೆಕ್ಸ್ಟ್ ಸಬ್ಜೆಕ್ಟ್ ನೆಕ್ಸ್ಟ್ ಕನ್ಸೆಪ್ಟ್ ಈಸ್ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ. ಹೌದು, ಬಟ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಎನ್ಸಿಸ್ಟ್ರಲ್ ಅಂದ್ರೆ ಏನು ಅಂತ. ಅದಕ್ಕೆ ನಾವು ಈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು ಹೇಳ್ತಾರೆ, ಮಾಧವ ರಾಜ ನಾಯ್ಕ್ ಕೇಸಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಹಾಗಂದ್ರೆ ಏನು ಅಂತ, ಮಾಧವ ರಾಜ ನಾಯ್ಕ್ ವರ್ಸಸ್ ಕೆ ಶ್ರೀಧರ್ ನಾಯ್ಕ್ ಕೇಸಲ್ಲಿ 2009 ಅಲ್ಲಿ ಕರ್ನಾಟಕದ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಅದು. ದಿ ಪ್ರಾಪರ್ಟಿ ಅಕ್ವೈರ್ಡ್ ವಿತ್ ದ ಏಡ್ ಆಫ್ ದಿ ancestral ಪ್ರಾಪರ್ಟಿ and property acquired by individual co-partner without such aid but treated by them as property for the whole family, adu joint family property which is not ancestral anta. To give an example on this, I am working as a judge now in the High Court. I acquired the property out of my own salary savings. And I can claim that it is my exclusive property. So it is my separate property. If I purchase the property with the help of the proceeds of my agricultural operations, it is an ancestral property income that property acquired with the aid of the property and property acquired by individual co-passers without such aid, but treated by them as property of the whole family. ಅದು joint family property, which is not ancestral. ಹಾಗೆ ಮತ್ತೊಂದು ಎಕ್ಸಾಂಪಲ್ ತಗೊಂಡಾಗ I purchase a property by using my salary sale. I throw the said property into a joint family property and always treat the said property as joint family property. ಅದು ancestral property ಅಲ್ಲ, but ಆದ್ರೆ joint family property ಅಂತ ನಾವು ಹೇಳ್ಬೋದು ಅಂತ what the Supreme Court says, what our own High Court says in K. Madhava Raja Naik versus K. Sridhara Naik. Reported in, it is available in 2009 SEC Online Karnataka page 614. So it is equally true of joint family property where sufficient individuals have been used by the co-partner to purchase the property. Then if the joint family proceeds are being utilized for purchase of the property, that will be a joint family property, but it is not ancestral property. And now we can very well assess. ಅದಕ್ಕೆ day in and out you hear the words doctrine of blending ಅಂತ what we say. Doctrine of blending ಅಂದ್ರೆ property thrown into a common hodgepodge or a common stock is called as the concept is called as a doctrine of blending. As I told, as I gave an example on that, if I purchase property of my own by using my salary savings, if I include the said property in the joint family property and I'll treat the said property as a joint family property, then I am throwing then my property into a common stock. That is called as doctrine of blending. Andre, abandoning my right over the property in question, I am including the said property into the common stock. That is called as a doctrine of blending. It has been well discussed in this Madhava Nayaka judgment. So we understood the meaning of joint family property, co-person property, apratibandha, obstructilities, unrelated, co-person property, gen property. Then what is this separate property? Separate property andre all property other than co-possessory property is called as separate property. ಯಾವ ಒಂದು ಪ್ರಾಪರ್ಟಿ ಯಾವ co-possessory ಪ್ರಾಪರ್ಟಿ ಅಲ್ವೋ ಅದೆಲ್ಲ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಅಲ್ವೋ ಅದೆಲ್ಲ ಸೆಪರೇಟ್ ಪ್ರಾಪರ್ಟಿ ಆಗುತ್ತೆ ಅಂತ ವಾಟ್ ದಿಸ್ ಸೆಪರೇಟ್ ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡ್ಸ್ ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಪ್ರಾಪರ್ಟಿ. ಅಂದ್ರೆ ಅಂಡರ್ ದಿ ಪ್ರೊವಿಷನ್ಸ್ ಆಫ್ ಹಿಂದೂ ಲಾ, even if a Hindu member of a joint family, he may possess separate property. The term self-acquired indicates that the property has been acquired by a co-partner by his own exertion without assistance of family funds. ಯಾವುದೇ ಒಂದು ಫ್ಯಾಮಿಲಿ ಫಂಡ್ಸ್ ಅನ್ನ ಉಪಯೋಗ ಮಾಡದೆ ತನ್ನ ಓನ್ ಸೇವಿಂಗ್ ದಿಂದ ಆ ಪ್ರಾಪರ್ಟಿಯನ್ನ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರೆ ಅದು ಇಟ್ ಬಿಕಮ್ಸ್ ದಿ ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಪ್ರಾಪರ್ಟಿ ಆಗುತ್ತೆ. that can be termed as self acquired property. ಹಾಗೆ when separate property self property becomes ancestral ಅಂತ ನಾವು ನೋಡಿದವಾಗ ಈಗ the judges now honorable judges who are retired and honorables who are working, the retired judges must have encountered the suit seeking partition, but the suit property may be separate for the plaintiff's property. ಅಲ್ಲಿ ಈ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಎವರ್ಮೆಂಟ್ ಮಾಡಿರ್ತಾರೆ ಅದು ಎನ್ಸಿಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ, ಆದ್ರೆ ಡಿಫೆಂಡೆಂಟ್ ಟೇಕ್ಸ್ ಅಪ್ ಅ ಡಿಫೆನ್ಸ್ ದಟ್ ಇಟ್ ಇಸ್ ಸೆಪರೇಟ್ ಪ್ರಾಪರ್ಟಿ. In such situations, the judges as well as the advocates have to read the pleadings properly. ಅಂದ್ರೆ ಸಿವಿಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಆಲ್ವೇಸ್ pleadings plays an important role. Pleadings are sacrosanct ಅಂತ ಹೇಳ್ತಾರೆ. ಹಾಗಿದ್ದಾಗ cautiously the court has to decide such a less bit before the court. Otherwise, a person who is possessing separate property, if you treat the said property as the ancestral property, if you effect a partition and decree the suit of the plaintiff, then the person who has acquired a property of his self-earning will lose his right of the property in question. So, hagiruvaga, when separate property, self-acquired property in the plead madadaga, the advocates must plead it properly. The court has to plead in a proper manner. Andre, hage ನಾವು decide casual ಆಗಿ ನಾವು ಅದನ್ನ ತಗೊಂಡು ನಾವು ಮಾಡ್ಬಿಟ್ರೆ self-acquired property ಅಂತ ಮಾಡದಕೊಂಡವನಿಗೆ we are doing injustice to such persons. So ಹಾಗಿದ್ದವಾಗ partition should decide ಮಾಡಬೇಕಾದ್ರೆ these are all concepts which have to be understood by the judges as well as the lawyers. So ಹಾಗಿರೋದ್ರಿಂದ ಅದಕ್ಕೆ several examples ಕೊಡಬಹುದು. ಆದ್ರೆ while deciding the partition suit, these concepts have to be understood by the judges as well as the lawyers. ಅದಕ್ಕೆ the Honorable Supreme Court of India in the Commissioner of Wealth Tax, Kanpur versus Chandrasen case ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಅಲ್ಲಿ the question arose before Supreme Court with regard to the interpretation of section 4 and 8 of the Hindu Succession Act 1956. ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ section 8 of the Hindu Succession Act 1956, the property of the father who dies intestate devolves on his son in his individual capacity and not as a karta of his own family. Section 8 lays down the scheme of succession to the property of a Hindu dying intestate. The schedule classified the heirs on whom such property should devolve. Those specified in class 1 took simultaneously to the exclusion of all the others ಅಂತ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಈ ಕಾನ್ಸೆಪ್ಟ್ ಅನ್ನ ಡಿಸೈಡ್ ಮಾಡಿ ಅವಾಗ ಕೋರ್ಟ್ ಹಾಗೆ ನಾವು ಅದನ್ನ ಡಿಸೈಡ್ ಮಾಡಬೇಕು ಅಂತ they have laid down the law. So that judgment has to be remembered, has to be read by the. Again, coming to this Pushpalata case, which is in 2019 Karnataka 3-2 division bench judgment ali. If succession of a self-acquired property idre of a male Hindu takes place among his heirs in accordance to section 8 of the Hindu Succession Act, the share that every member takes will be held by each of them as his or her own separate property ಅಂತ. ಅಕಸ್ಮಾತ್ ಈ ಪುಷ್ಪದ ಕೇಸ್ ಅಂತ ಅದು ನೋಡಿದವಾಗ ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಪ್ರಾಪರ್ಟಿ ಆಫ್ ಎ ಮೇಲ್ ಹಿಂದೂ ಇದ್ರಿ ಅವಾಗ ಪಾರ್ಟಿಷನ್ ಹಾಕಿದಾಗ we have to apply the provisions of section 8 of the Hindu Succession Act. ಅದಕ್ಕೆ ಪೂರಕವಾಗಿ ಅಂದ್ರೆ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಗೆ ಪೂರಕವಾಗಿ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇನ್ ಅರಸ್ನೂರ್ ಸಿಂಗ್ ವರ್ಸಸ್ ಹರ್ಪಾಲ್ ಸಿಕೌರ್ ಕೇಸ್ ಅಲ್ಲಿ 2020 part 14 value 14 SCC page 436 ಅಲ್ಲಿ in para 7 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, under Mithakshara law, whenever a male ancestor inherits any property from any of his paternal ancestor up to 3 degrees above him, then his male legal heirs up to 3 degrees below him would get an equal right as co-partner in that property ಅಂತ what the Supreme Court says. ಅದಕ್ಕೆ ನಾವು ಮತ್ತೆ ಯಾಕಂದ್ರೆ why the judgments of the apex court as well as the high court are important ಅಂದವಾಗ some laws have been laid down by the apex court as well as the high court, how these provisions have to be interpreted by the court. ಹಾಗೆ ಗೋವಿಂದಬಾಯಿ ಛೋಟಾಬಾಯಿ ಕೇಸ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ says Mithakshara father has absolute right of disposition over his self-acquired property, to which no exception can be taken by his male descendants ಅಂತ what the Supreme Court says. ಹೀಗಿರೋದ್ರಿಂದ ನಾವು how to determine if a property is ancestral or separate property ಅಂತ ನೋಡಿದವಾಗ there are category of judgments being rendered by the Honorable High Court as well as Supreme Court. ಅವೆಲ್ಲ ಓದಿ ನೋಡಿದವಾಗ ಗೊತ್ತಾಗುತ್ತೆ how we have to decide the partition suits ಅಂತ. ಹಾಗೆ ಇಲ್ಲಿ ಕಾನ್ಸೆಪ್ಟ್ ಹಾಗೆ ಬಂದಾಗ ಸೆಕ್ಷನ್ 6 ಯಾಕೆ ಈ ಇವತ್ತು ಪಾಠ ಇದು ಇವತ್ತು ಲೆಕ್ಚರ್ ಇರೋದು ಸೆಕ್ಷನ್ 6 ಇರೋದ್ರಿಂದ, ಅಡ್ವೊಕೇಟ್ಸ್ ಇರೋದ್ರಿಂದ, ಸ್ಟೂಡೆಂಟ್ಸ್ ಇರೋದ್ರಿಂದ we also must know that incidents of joint family are co-personal property ಅಂತ ನಾವು ತಿಳ್ಕೊಬೇಕಾಗುತ್ತೆ. Incidents of joint family are co-personal property ಅಂದ್ರೆ while determining while deciding the partition suits with respect to the ancestral property, one should know the rights and liabilities of the co-partners. Idre matra we can decide the partition suits very well, effectively ಅಂತ. ಅಂದ್ರೆ ಆ ಪ್ರಾಪರ್ಟಿ ಏನ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬರ್ದಿರ್ತಾರೆ ಅಥವಾ WS ಅಲ್ಲಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿರ್ತಾರೆ, ಅವಾಗ our first of the court has to see is that the nature of the acquisition of property hage bantu. Even while drafting the plaint, while drafting the written statement, it is the duty of the advocate to see that if a partition suit is filed, how that property, nature of the property hage acquire ಆಯ್ತು co-person property hage bantu anta ನಾವು decide ಮಾಡಬೇಕು. ಆಮೇಲೆ the right to work out their shares by seeking partition. ಅವಾಗ ಎಷ್ಟೋ ಜನ ಸತ್ತೋಗಿರ್ತಾರೆ. So effect of death of the co-persons ನೋಡ್ಬೇಕು. The right of alienation of undivided share ನೋಡ್ಬೇಕು. These aspects are called as incidents of co-parsory ownership ಅಂತ ಹೇಳ್ತಾರೆ. ಅಂದ್ರೆ ಒಂದು ಪಾರ್ಟಿಷನ್ ವ್ಯಾಜ್ಯ ಬಂದವಾಗ ಈ ಇನ್ಸಿಡೆಂಟ್ಸ್ ಆಫ್ ಪಾರ್ಟಿಷನ್ ನಾವು ನೋಡಿ ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ರೆ ಮಾತ್ರ ಯು ಕ್ಯಾನ್ ಡಿಸೈಡ್ ದಿ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ಸ್ ಇಫೆಕ್ಟಿವ್ಲಿ ಅಂತ ವಾಟ್ ಇಸ್ ಡಿಸೈಡ್. ಮೊದಲು ಆ ನೇಚರ್ ಆಫ್ ದ ಅಕ್ವಿಸಿಷನ್ ಹೇಗೆ ಬಂತು, ಆ ಫ್ಯಾಮಿಲಿಗೆ ಹೇಗೆ ಬಂತು, ಅದರಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಕೇಳಬೇಕಾದ್ರೆ ಏನೇನು ಯಾರ್ಯಾರು ಎಷ್ಟು ಶೇರ್ ಇರ್ತದೆ, ದೆನ್ ಆ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಎಷ್ಟು ಜನ ಸತ್ರು, ಎಷ್ಟು ಜನ ಜೀವಂತಿದ್ದಾರೆ, ಎಷ್ಟು ಜನಗೆ ಹಕ್ಕು ಬರ್ತದೆ ಆಸ್ ಪರ್ ದಿ ಓಲ್ಡ್ ಆಕ್ಟ್ 1956 ಆಕ್ಟ್, ಎಷ್ಟು ಜನಕ್ಕೆ 2000 ನಮ್ಮ ಕರ್ನಾಟಕ ಗವರ್ಮೆಂಟ್ ಎಷ್ಟು ಬರ್ತದೆ, ಹಾಗೆ 2005 ಆಕ್ಟ್ ಮೇಲೆ ಎಷ್ಟು ಬರ್ತದೆ ಅಂತ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ರೆ ದಿ ಎವ್ರಿ ಜಡ್ಜ್ ಕ್ಯಾನ್ ಡಿಸೈಡ್ ದಿ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ವೆರಿ ಇಫೆಕ್ಟಿವ್ಲಿ ಅಂತ. So these aspects have to be remembered by the judges as well as the lawyers. When a daughter has been conferred the status of a co-partner under the enactment, that is Karnataka Amendment ಆಯ್ತು, Central Amendment ಆಯ್ತು 2005 ಅಲ್ಲಿ, while deciding the rights of the co-daughter, we have to keep in mind the incidents of partition and the Honorable Apex Court in Ghamandi Ram case ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, way back in 1969 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಈ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ವರ್ಸಸ್ ಗವರ್ಮೆಂಟ್ ರಾಮ್ ಕೇಸ್ ಅಲ್ಲಿ 1969 ವಾಲ್ಯೂಮ್ 2 SCC ಪೇಜ್ 33 ಹೇಳ್ತಾರೆ, 6 ಇನ್ಸಿಡೆಂಟ್ಸ್ ಆಫ್ co-partnership ಅಂಡರ್ ದಿ ಇಮಿತಾಕ್ಸರ್ ಲಾ ಅಂತ ಹೇಳ್ತಾರೆ. 6 ಇನ್ಸಿಡೆಂಟ್ ಇದೆ. ಅದರಲ್ಲಿ ನಂಬರ್ 1 ಹೈಕೋರ್ಟ್, lineal male descendants of a person up to the 3rd generation acquire birth ownership in the ancestral property of such a person. Secondly, that such a descendants can at any time work out their rights by asking for partition. Thirdly, that till partition, each member has got ownership extending over the entire property conjointly with the rest. Fourthly, that as a result of such a co-ownership, the possession and enjoyment of the properties is common. Fifthly, that no alienation of the property is possible unless it be for necessity, without the concurrence of the co-partners. And lastly, that the interest of the deceased member lapses on his death to the survivors. You are a concept and lawyers, judges artha madkonbitre, it is very easy for deciding the partition suits. So therefore, ಈ ಎಲ್ಲ ನಾವು ಕಾನ್ಸೆಪ್ಟ್ ಅನ್ನು ಅರ್ಥ ಮಾಡ್ಕೊಂಡಾಗ ನಮ್ಗೆ ಗೊತ್ತು, in the year 2018 we had one case of Danamma versus Amar ಅಂತ Danamma case. ಈ Danamma case Supreme Court has said that daughter as a co-partner shall be responsible for all the debts and liabilities. ಈಗ ನೀವು ನೋಡಿರ್ಬೋದು ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಬರೀ ಪ್ರಾಪರ್ಟಿ ಮಾತ್ರ ಬೇಕು, ಲೈಬಿಲಿಟಿ ಬೇಡ ಅಂತ ಬರ್ತಾರೆ. ಆದ್ರೆ ದಾನಮ್ಮ ಕೇಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, when daughter as a co-partner shall be responsible for all the debts and liabilities, she is also, when she is entitled for a share in the property, she is also liable for debts and liabilities and what the Supreme Court says. And whatever the property comes into her hands as a co-partner. So this is also one of the incident of co-partnership is of a right of a, ಅಂದ್ರೆ ನೀವೆಲ್ಲ ತಮ್ಗೆಲ್ಲ ಗೊತ್ತಿರ್ಬೋದು, once a suit for partition has been filed, it is deemed that there is a severance of the joint family status in the family anta ಹೇಳ್ತಾರೆ. So hence the right of the co-partner emanate and flow from birth, now including daughters, which is an incident of the partition, ಅಥವಾ the concept of partition anta. Therefore it is very much clear that it is that right to seek partition has not been abrogated. It is not at all kept in abeyance, and now even a daughter who is a co-partner can very well claim partition by filing a suit for partition anta ಹೇಳ್ತಾರೆ. So ಹಾಗೆ ಈ separate property ಅಂತ ಬಂದಾಗ in day and out we experience that the defendants are plaintiff may take up in these properties by separate property non select property ಅಂತ ತಗೊಂಡಾಗ, even if he is a joint may possess separate property, but it is the burden is on him to prove that it is self-acquired property. ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಕೊಡಬೇಕು, ಅದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇರಬೇಕು, ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಇರಬೇಕು. ಎಲ್ಲ ಇದ್ರೆ ಮಾತ್ರ if the court is by applying judicious mind, if it feels that the particular defendant is able to establish that it is self-acquired property, then partition cannot be effected on the minded property. ಹಾಗೆ ನಾವು we also come across the concept of the joint tenants and tenants in common ಅಂತ what we say. ಯಾಕಂದ್ರೆ if you compare the Hindu law with the Mohammedan law, Mohammedan law there is no concept of joint in the family. But now it is our experience in some courts, sitting at appellate court. ಅವಾಗ ನೋಡಿದ್ವಿ ನಾವು, ನಮ್ಮ ಜಡ್ಜಸ್ by applying the Hindu law they effected a partition in the Mohammedan suit. Mohammedan suit ಫೈಲ್ ಮಾಡಿರ್ತಾನೆ, ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಕನ್ಸೆಪ್ಟ್ ಡಿಗ್ರಿ ಮಾಡೋ ಸೂಟ್ ಎಷ್ಟೋ ಒಂದು ಹಾಗೆ ಇರ್ತದೆ. ಆದ್ರೆ ಈ ಅಲ್ಲಿ ಕನ್ಸೆಪ್ಟ್ ಆಫ್ ಟೆನೆಂಟ್ಸ್ ಇನ್ ಕಾಮನ್ ಇಸ್ ಇನ್ ಫೋರ್ಸ್. ಸೊ while deciding the partition suit need to know that concept of survivorship ಅಂದ್ರೆ ಏನು, succession vis-a-vis the joint tenants in common ಅಂತ ನಾವು ಅರ್ಥ ಮಾಡಿಕೊಂಡ್ರೆ the judge or the court can well decide the partition suits effectively ಅಂತ. These are all the concepts which are required to be understood by the judges as well as the lawyers while dealing with the partition suits. ಅಂದ್ರೆ ಈ ಜಾಯಿಂಟ್ ಟೆನೆನ್ಸಿ ಅಂತ ಬರ್ತದೆ. ಈಗೆಲ್ಲ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಆಕ್ಟ್ ಬಂತು. ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ ಬಂದಾಗ ಜಾಯಿಂಟ್ ಟೆನೆನ್ಸಿಯಲ್ಲಿ ಎಷ್ಟೋ ಒಬ್ಬ 10 ಜನ ಬ್ರದರ್ಸ್ ಇರ್ತಾರೆ, ಅದರಲ್ಲಿ ಒಬ್ಬ ಫಾರ್ಮ್ ನಂಬರ್ 7 ತುಂಬುತ್ತಾನೆ. ಈ ಕ್ಲೇಮ್ಸ್ ಆಕ್ಯುಪೆನ್ಸ್ ರೈಟ್ಸ್ ಇನ್ ದ ಪ್ರಾಪರ್ಟಿ ಆನ್ ಬಿಹಾಫ್ ದಿ ಎಂಟೈರ್ ಫ್ಯಾಮಿಲಿ. ಇಟ್ ಇಸ್ ಜಾಯಿಂಟ್ ಟೆನೆನ್ಸಿ, ಬಟ್ ಫಾರ್ಮ್ ನಂಬರ್ 7 ತುಂಬಿದ ಅವನು ಮಾತ್ರ ಇರ್ತಾನೆ. ಆದ್ರೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಗ್ರಾಂಟೆಡ್ ದಿ ಆಕ್ಯುಪೆನ್ಸಿ ಟು ದಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಪರ್ಸನ್ ಹೂ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ದಿ ಫಾರ್ಮ್ ನಂಬರ್ 7. ಅವಾಗ ಹಿ ಕೆನಾಟ್ ಕ್ಲೇಮ್ ದಟ್ ಇಸ್ ಮೈ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಪ್ರಾಪರ್ಟಿ. ಯಾಕಂದ್ರೆ the Supreme Court says and the High Court also says in so many judgments that whatever the right given to the accused given to the one of the member of the family will endure the benefit of all the co-parcels ಅಂತ what the Supreme Court says and the High Court says. ಆಗಿರುವಾಗ joint tenancy implies unity of title and as well as unity of possession. Tenancy in common signifies only the unity of possession ಅಂತ what it is said. So ಹೀರೋದ್ರಿಂದ ಎಂತ ಎಲ್ಲ ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ದ ಬಂದವಾಗ ಇಟ್ ಇಸ್ ದ ಡ್ಯೂಟಿ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಟು ಸಿ ದಟ್ ದಿ ಪಾರ್ಟಿಷನ್ಸ್ ಆರ್ ಬಿಂಗ್ ಡಿಸೈಡೆಡ್ ಇಫೆಕ್ಟಿವ್ಲಿ ಅಂತ. ಅವಾಗ ನಾವು ಯಾವ್ದು ಕಾನೂನು ಅಪ್ಲೈ ಮಾಡಬೇಕು ಅಂತ ಒಂದು ಪ್ರಶ್ನೆ ಬರ್ತದೆ. 1956 ಮಾಡಬೇಕು ಅಥವಾ 1990 ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲೈ ಮಾಡಬೇಕು ಅಥವಾ 2005 ಅಮೆಂಡ್ ಮಾಡುವಾಗ ದಿ ಲಾ ಸೇಸ್ when a male Hindu dies after the commencement of the Hindu succession 996, having at the right of at the time of his death an interest in Mitaksara property, his interest in the property will devolve by survivorship upon the surviving members of the co-parcel as per section 6 of the Hindu Succession Act. The proposition is, it is an exception contained in section 30 of the Hindu Succession Act, making it clear that notwithstanding anything contained in the act, the interest of a male Hindu in the Mitaksara co-parcel property is a property that can be disposed of by him by will or other testamentary disposition. So this is how we have to understand the subject and decide the partition suits. ಹಾಗೆ ಕನ್ಸೆಪ್ಟ್ ಆಫ್ ಸರ್ವೈವರ್ಶಿಪ್ ಅಂತ ಅಂದ್ರೆ ಏನು ಅಂತ ಒಂದು ಪ್ರಶ್ನೆ ಬರ್ತದೆ while deciding the partition suit. So the concept of the survivorship prior to 2005 was recognized. ಆದರೆ ಈ ಕನ್ಸೆಪ್ಟ್ ಆಫ್ ದಿ ಸರ್ವೈವರ್ಶಿಪ್ ಇಸ್ ಗಿವನ್ ಎ ಕಂಪ್ಲೀಟ್ ಗೋ ಬೈ ಅಂಡರ್ ದಿ ಪ್ರೊವಿಷನ್ಸ್ ಆಫ್ ಹಿಂದೂ ಸಕ್ಸೆಷನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಕ್ಟ್ 2005. ಅದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನಾವು. ಅದಕ್ಕೆ ನಾವು ಅಗೇನ್ ವಿ ಹ್ಯಾವ್ ಟು ಗೋ ಬ್ಯಾಕ್ ಟು 1933 ಹಿಂದೂ ಲಾ, ಮೈಸೂರು ಹಿಂದೂ ಲಾ ವುಮೆನ್ಸ್ ರೈಟ್ ಆಕ್ಟ್ 1933 and also the Hindu Women's Right to Property Act 1937. Under the Mitaksara co-parcel, if a co-parcel dies, his undivided interest lapsed on the survivors. As per these two enactments, if a co-parcel died leaving behind a widow, then his undivided interest devolved upon such a widow and not on the surviving co-parcels. What is these two enactments says. So after enactment of Hindu Succession Act 1956, this concept of survivorship was further restricted, and as per the proviso to unamended section 6 of the Hindu Succession Act, in the absence of a surviving female relative specified in class 1 of the schedule, then the interest of the deceased co-parcel divided by survivorship upon the surviving members of the co-parcel. This is what we have to understand with regard to the survivorship. A daughter being the class 1 legal heir is entitled for a share out of the property fallen to the share of the deceased co-parcel, her father, when notional partition is effected under section 6B of the Hindu Succession Act, Karnataka Amendment 1990. So, similar restriction is also imposed now on the concept of survivorship as that of unamended provisions of section 6 of the Hindu Succession Act, section 6 of the 1956. But this section 6 plus 3 of the Hindu Succession Act 2005 has given a complete go-by to the concept of survivorship. So as per their said provision, if a Hindu dies after 9/9/2005, then his interest in the property of a joint Hindu family shall devolve by testamentary intestate succession, as the case may be, as per the provisions of the Act, are not by survivorship. Always the death of a co-parcel, male ancestor, always plays an important role to decide survivorship because of this Act. Act apply this is very important. So the Hindu Succession Amendment Act 2005 recognizes only testamentary succession or intestate succession and not by succession by survivorship. So under the unamended section 6 of the Succession Act, in the absence of a female class 1 legal heir, then such interest devolved upon survivors are to class 2 heirs. Adhike, the Supreme Court in Vijnaneshwara case in para 66 has stated that with respect to a Hindu who dies after the commencement of Amendment Act 2005, as provided in section 6 of class 3, his interest shall pass by testamentary or intestate succession and not by survivorship. Keeping in mind the provision section 6 plus 3 of the Hindu Succession Act, the Supreme Court has laid down the law now. Now it has become final and attained finality, and there is no other further judgments. So in case of death of a co-parcel after 9/9/2005, succession is not by survivorship, but it may be by intestate succession or tested succession. The law says that succession cannot be in abeyance. Succession and it cannot be kept in abeyance. So it is important to note that succession can never be in abeyance. That is, it cannot never lie in vacuum. The moment a person dies intestate, his heirs become entitled to succeed to his property. If there is a will, the succession will be as per the will. ಯಾವುದೋ ಒಂದು ಕುಟುಂಬದಲ್ಲಿ ಒಬ್ಬ ancestor ಇರ್ತಾನೆ, if there is application of 2005 Amendment Act, ಅವನ ಸತ್ತ ತಕ್ಷಣ ಅವನ ಮಕ್ಕಳಿಗೆಲ್ಲ ಹಕ್ಕು ಬರ್ತದೆ. ಅಂದ್ರೆ ಬರ್ತ್ ರೈಟ್ ಇದ್ದೇ ಇರ್ತದೆ ಅವರಿಗೆ. if a partition suit is filed, ಅಕಸ್ಮಾತ್ ಅವನು ವಿಲ್ ಬರೆದ್ರೆ ವಿಲ್ ಮುಖಾಂತರ ಹೋಗುತ್ತೆ. if the will ಬರಲಿಲ್ಲ ಅಂತಂದ್ರೆ as per the provisions of the Hindu Succession Act, the partition has to take place. ಅದಕ್ಕೆ ನೀವು ಮತ್ತೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಅಂದ್ರೆ ಏನು ಕಾಳಮ್ಮ ವರ್ಸಸ್ ಕೆ.ಬಿ. ಧನಲಕ್ಷ್ಮಿ ಕೇಸಲ್ಲಿ ILR 2014 ಕರ್ನಾಟಕ ಪೇಜ್ 2305 ಅಲ್ಲಿ in para 22 ಇಲ್ಲಿ ರೂಲ್ಸ್ ಆಫ್ ಸಕ್ಸೆಷನ್ have been Hindu Succession Act 1956 have been discussed by the Honorable High Court. So it is well settled that succession never remains in abeyance and takes effect immediately at the exact moment of the death of a person by operation of law anta what the Supreme our High Court said. So ಇಷ್ಟೆಲ್ಲ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಂಡಾಗ what are the duties of the courts and lawyers in dealing with the partition suit ಅಂತ ನೋಡಿದವಾಗ, while dealing with the partition suits, courts must take extreme care and caution regarding the nature of the property. ಅದು ancestral ಹೌದು ಅಥವಾ self acquired absolute property of female under section 15 Act, death of a co-parcel ಯಾವಾಗ ಆಯ್ತು, section 6A to 6C ಅಪ್ಲೈ ಆಗುತ್ತಾ, ಅವನ 1990 ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲೈ ಆಗುತ್ತಾ, 2005 ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲೈ ಆಗುತ್ತಾ, ಇದೆಲ್ಲ ಅರ್ಥ ಮಾಡಿಕೊಂಡು you can decide the partition suits. So ಅದಕ್ಕೆ the honorable apex court in Shashidhar versus Ashwini Uma Matar case ಅಲ್ಲಿ please note down the judgment and read ಈ ಜಜ್ಮೆಂಟ್ ಓದ್ಬಿಟ್ರೆ ನೀವು ಹೇಗೆ ಪಾರ್ಟಿಷನ್ ನಡೆಸಬೇಕು, ಹೇಗೆ ಪಾರ್ಟಿಷನ್ ಡಿಸೈಡ್ ಮಾಡಬೇಕು ಅಂತ ಚೆನ್ನಾಗಿ ಬರುತ್ತೆ. 2015 ವ್ಯಾಲ್ಯೂಮ್ 11 SCCPS 269 ಅಲ್ಲಿ when a suit is filed, 2015 ವ್ಯಾಲ್ಯೂಮ್ 11 SCCPS 269 ಅಲ್ಲಿ page 276 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, when a suit is filed by a co-sharer, co-partner, co-owner, joint owner, as the case may be, for partition separate position of each share, it is necessary for the court to examine. ಒಂದು ಸುಮಾರು ಎಕ್ಸಾಂಪಲ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಯಾವ ತರ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕಂದ್ರೆ. in all there are 4 concepts have been stated by the Honorable Supreme Court, directing the court to adhere to all these guidelines and decide the partition source. I request all of you to go through the judgment so that you have a better understanding of the position of law with regard to the deciding of the partition source. Please.
Well, let me also let me check what's the time available for this online link.
Yes, yes.
Madam Ragini, can you tell? I think it is 7:23. Madam.
Yes.
Yes,
Link.
sir.
ಇನ್ನು ಬಹಳ ಹೇಳೋದು ಬಹಳ ಇದೆ. ಒಂದು ಇದರಲ್ಲಿ ಆಗಲ್ಲ ಅದು. It takes time. Okay then. These are all the things, these are all the facts which the lawyers as well as the judges have to remember, have to always, ಅದಕ್ಕೆ ನಾನು ಎಲ್ಲ, even in the academy when I was a director there and when I was really a principal teacher, I used to request all my officers to read judgment every day. One day ಯಾವುದೋ ಒಂದು ಜಜ್ಮೆಂಟ್ ಓದಿ, so that will be helpful to you ಅಂತ ಹೇಳ್ತಿದ್ದೆ. ಹಾಗೆ ಲಾಯರ್ಸ್ಗೆ ಹೇಳ್ತಿದ್ದೆ ನಾನು, ಲಾಯರ್ಸ್ಗೆ ಓದೋದೆಲ್ಲ ಕಡಿಮೆ ಆಗ್ಬಿಟ್ಟಿದೆ ಇವಾಗ. Even I request the principal of the college, even the university chancellor, to imbibe the qualities of reading the judgments. ಯಾಕಂದ್ರೆ ರೀಡಿಂಗ್ ಅವೆಲ್ಲ ಮೊಬೈಲ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಇವಾಗ. ನಾವು ಲಾಸ್ ಯೂನಿವರ್ಸಿಟಿ ಅವರು ಇದ್ದಾರೆ, so I request them. Even previously I requested Chidan Reddy also to imbibe the qualities of reading the judgments, reading the textbooks, etc. so that ಯಾಕಂದ್ರೆ ನೀವು ಹೇಗೆ ಕಲಿಸ್ತಿರೋ ಹಾಗೆ ಇಲ್ಲಿ ಲಾಯರ್ ಆಗಿ ಬರ್ತಾರೆ. They're all future judiciary. ಈಗ ನಾವು ನೋಡ್ತಾ ಇದ್ವಿ ಕ್ವಾಲಿಟಿ ಆಸ್ ಇಟ್ ಇಸ್ ಇಂಡೋರ್ ದಿಸ್ ಥಿಂಗ್, ಐ ಆಮ್ ಟೆಲ್ಲಿಂಗ್ ಕ್ವಾಲಿಟಿ ಇಸ್ ಡಿಟ್ರಾಯಿಟಿಂಗ್. ಅಂಡ್ ಈಗ ಸೋ ಮೆನಿ ಜಡ್ಜಸ್ ಆರ್ ಹಿಯರ್, ರಿಟೈರ್ಡ್ ಜಡ್ಜಸ್ ಆರ್ ಹಿಯರ್. ಅವರಿಗೆಲ್ಲ ನಾವು ನಮಸ್ಕಾರ ಮಾಡ್ಬೇಕು. ಯಾವ ತರ ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ದಿದ್ದಾರೆ ಅಂತ. ಮುಚ್ಚಂಡಿ ಸಾಹೇಬ್ ಇರ್ಬೋದು, ವೈದ್ಯ ಸಾಹೇಬ್ ಇರ್ಬೋದು, ದೇರ್ ಆರ್ ಸೋ ಮೆನಿ ಜಡ್ಜಸ್, ಜಸ್ಟಿಸ್ ಆನಂದ್ ಬೆರ್ರೆಡ್ಡಿ ಸಾಹೇಬ್ ಇರ್ಬೋದು. ಯಾವ ತರ ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ದಿದ್ದಾರೆ ಅಂದ್ರೆ ದೇ ಯೂಸ್ ಟು ಟೇಕ್ ಟೂ ಮಚ್ ಪೇನ್ ಟು ರೈಟ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಅವ್ರಿಗೆ ಮನೆಗೆಲ್ಲ ದೇ ಆರ್ sacrificed ಎಂಟೈರ್ ಫ್ಯಾಮಿಲಿ ಲೈಫ್ and they have devoted their entire life to the judiciary. 20 ವರ್ಷ 30 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ. ಆ ತರ ನಮ್ಮಲ್ಲಿ ಬರ್ಬೇಕೀಗ. That quality has to be cultivated to the advocates. Advocates will become tomorrow, they may become high court judge, they become district judge, they become municipal, etc. ಹಾಗಿರೋದ್ರಿಂದ I request the law university faculties to cultivate to imbibe the qualities of reading the judgments, reading the textbooks, and so that ಆಮೇಲೆ ಪ್ರಾಕ್ಟಿಕಲ್ ಆಗಿ ನೀವು ಮುಟ್ಕೋಟ್ ಮಾಡಬೇಕು. ಅದೊಂದು ನಾನು ಯಾವಾಗ್ಲೂ ಹೇಳೋದು, ಎಲ್ಲ ಇದೆ ಮುಟ್ಕೋಟ್ ಹೋದವಾಗ ನೀವೇನ್ ಮಾಡ್ತೀರಿ, ಬೇರೆ ಯಾವ್ದೋ ಒಂದು ಈ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮೇಲೆ ಅಥವಾ ಒಂದು ಫಾರಿನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಮೇಲೆ ಒಂದು ಪ್ರಾಬ್ಲಮ್ ಕೊಟ್ಟು ಅದನ್ನ ನೀವು ಮಾಡಂತ ಹೇಳ್ತೀರಿ. ಬಟ್ ನಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದು ಬೇರೆ ಇಲ್ಲ ಸರ್. ಅದ್ ನಾವು ಇರೋದು ಇಂಡಿಯನ್ ಸೂಟು, ಪಾರ್ಟಿಷನ್ ಸೂಟು, ಡೆಕ್ಲರೇಷನ್ ಸೂಟು, ರಿಟ್ ಪಿಟಿಷನ್ ಅದೆಲ್ಲ ಇಲ್ಲಿ ಬರ್ತದೆ, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಬರ್ತದೆ. ಅಂತ ಕೊಟ್ಟು ಕೋರ್ಟ್ ಮಾಡಿಸಿದ್ರೆ ದೇ ವಿಲ್ ಹ್ಯಾವ್ ಸಮ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಅಬೌಟ್ ದಿ ಪ್ರೆಸೆಂಟ್ ನಮ್ದು ಏನು ನಡೆದಿದೆ ಅದು ಗೊತ್ತಾಗುತ್ತೆ. ನೀವು ಯಾವ್ದೋ ಒಂದು ಫಾರಿನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟು ಇನ್ನು ಮುಟ್ಕೋಟ್ ಮಾಡಿ ಅಂತಂದ್ರೆ ಅವ್ರ ಲ್ಯಾಂಗ್ವೇಜ್ ಹೈ ಇರ್ತದೆ, ಅವ್ರಿಗೆ ಅರ್ಥ ಮಾಡ್ಕೋದು ಗೊತ್ತಿಲ್ಲ. ಈಗ ಯಾಕಂದ್ರೆ ಮೋಸ್ಟ್ ಆಫ್ ದ ಸ್ಟೂಡೆಂಟ್ಸ್ ಆರ್ ಫ್ರಮ್ ಕನ್ನಡ ಮೀಡಿಯಂ, ದೇ ನಾಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ವಾಟ್ ದೇ ಇಂಗ್ಲಿಷ್ ಮಾತಾಡೋಕೆ ಹೆದರಿ ಬಿಡ್ತಾರೆ. ಸೊ ಅದೆಲ್ಲ ತಾವು ಸ್ವಲ್ಪ ತಿಳ್ಕೋಬೇಕು. ಲಾ ಕಾಲೇಜ್ ಫ್ಯಾಕಲ್ಟಿ ಅವರೆಲ್ಲ ಯಾರು ಇದ್ದೀರಿ ಎಲ್ಲ ಅಲ್ಲಿ ಕಲ್ಸ್ಬೇಕಾದ್ರೆ ಸಹಿತ ಸ್ವಲ್ಪ ಹೇಳ್ಬೇಕು. ಅಲ್ಲಿ ನೀವು ಮುಟ್ಕೋಟ್ ಮಾಡ್ತೀರಿ ಕಾಲೇಜಲ್ಲಿ, please take the disposal files from the concerned courts, requesting the concerned judge there. They will give certified, they will give copies to you. ಅವನ ಮುಟ್ಕೋಟ್ ಮಾಡಿ ಅಸಾಲ್ಟ್ ಕೇಸ್ ಇರ್ಬೋದು, ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇರ್ಬೋದು, ಸಿವಿಲ್ ಕೇಸ್ ಇರ್ಬೋದು, ಯಾವುದೇ ಇದ್ರು ಸಹಿತ ಅದನ್ನ ನೀವು ಮುಟ್ಕೋಟ್ ಮಾಡಿದ್ರೆ ಅದೇ ಬಂದು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾರ. ಅದ್ ಬಿಟ್ಟು ನೀವು ಯಾವ್ದೋ ಫಾರಿನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟು ಕನ್ಫ್ಯೂಸ್ ಮೇಲೆ ಕೊಟ್ಟು ಹಾಗೆ ಮಾಡಿ ಹೀಗೆ ಮಾಡಿ ಅಗ್ರಿಮೆಂಟ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ನಮಗೆ ಉಪಯೋಗ ಆಗಲ್ಲ. ಅದೆಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇದೆಲ್ಲ ಇರ್ತದೆ. ಅದನ್ನೆಲ್ಲ ನಾವು ಸ್ವಲ್ಪ ಅದನ್ನ ಮಾಡಿದ್ರೆ ವಿಲ್ ಗೆಟ್ ಸಮ್ ಗುಡ್ ಕ್ವಾಲಿಟೀಸ್. ಯಾಕಂದ್ರೆ ಮೋಸ್ಟ್ ಆಫ್ ದಿ ಅಡ್ವೊಕೇಟ್ಸ್ now are not coming to the judiciary or coming to the joining the bar. They are preferring to go to corporate sector. There they will get a handsome salary. ಅದಕ್ಕೆ ತಾವು ಸ್ವಲ್ಪ ಅದಕ್ಕೆ ಒಂದು ಅರ್ಥ ಕೊಟ್ಟು ನಾವು ಲಾ ಕಾಲೇಜ್ ಅವರು ಲಾ ಯೂನಿವರ್ಸಿಟಿ ಅವರು ಎಸ್ಪೆಷಲಿ, ಆಮೇಲೆ ಯೂನಿವರ್ಸಿಟಿ ಮೇಲೆ ಬಹಳ ಕಂಪ್ಲೇಂಟ್ ಮರ್ಸೆ ಕೊಡಲ್ಲ ಅಂತ ಎಲ್ಲರೂ ಹೇಳ್ತಾರೆ. ಆ ತರ ಸ್ವಲ್ಪ ಲಿಬರಲ್ ಆಗಿ ಏನೋ ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದಾಗತ್ತೆ ಅಂತ. ದಿಸ್ ಇಸ್ ಹೌ I wanted to convey to this and as the time is up, it is already 7:27. I heartily extend my heartfelt thanks to the organizers, Amit Deshpande, Kadaganchi, Kardalli and other organizers who have contacted me and asked me to share my few thoughts on this. So I extend, and I hope that whatever we have discussed now will be helpful to the advocates, helpful to the judges who are still in the judiciary, and also to enrich the knowledge. Actually, reading is a vehicle of knowledge anta ಹೇಳ್ತಾರೆ. Hard work is the only substitute for intelligence. I request all the law students to cultivate the habit of reading and attending the court. And ನೀವು ಯಾರೋ senior ಹತ್ರ senior ಏನು ಕಲಿಸಲ್ಲ, so please attend the court, sit in the court. Open court is the best guide for you. ಅಲ್ಲಿ ನೀವು ಎಷ್ಟೋ ಕಲಿತೀರಿ, ಆ ಆಫೀಸಲ್ಲಿ ಕಲಿಸೋದು ಏನು ಕಲಿಸೋದು ಯಾರು ಸೀನಿಯರ್ ಕಲಿಸೋದಿಲ್ಲ. ಅದನ್ನೆಲ್ಲ ತಿಳ್ಕೊಂಡು ಒಳ್ಳೆ ಲಾಯರ್ ಆಗಿ ಯುವರ್ ಆಲ್ ಫ್ಯೂಚರ್ ಜುಡಿಷಿಯರಿ ಅಂತ ಹೇಳ್ತಾ, once again I extend my thanks. I hope that this discussion is helpful to you all. Thank you all. I thank Ravindra Vaidya sir, Muchandi sir, as well as Honorable Justice Bhaira Reddy sir for having joined this and heard me patiently. Thank you.
ಇಂದು ವಿಷಯದ ಕುರಿತು ವಿಸ್ತೃತ ಉಪನ್ಯಾಸ ನೀಡಿದ ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಶ್ರೀ R.D. ಹುದ್ದಾರ್ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನ ಅಲಂಕರಿಸಿದ ಡಾಕ್ಟರ್ ಸಿ ಬಸವರಾಜು, ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಲಾ ಯೂನಿವರ್ಸಿಟಿ ಹುಬ್ಬಳ್ಳಿ ಆನರಬಲ್ ವೈಸ್ ಚಾನ್ಸಲರ್ ಅವರಿಗೆ ಅಧ್ಯಕ್ಷೀಯ ಭಾಷಣ ನೀಡಬೇಕೆಂದು ವಿನಂತಿಸುತ್ತೇನೆ. ಸರ್ ಪ್ಲೀಸ್.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ಮೊದಲನೇದಾಗಿ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದಂತಹ R.D. ಹುದ್ದಾರ್ ಅವರೇ, ಈ ಒಂದು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಟ್ರಸ್ಟ್ ನ ಜವಾಬ್ದಾರಿಯನ್ನು ಹೊತ್ಕೊಂಡು ಇಂತಹ ಒಂದು ವಿಚಾರ ವಿನಿಮಯ ಮಾಡ್ಕೊಳ್ತಕ್ಕಂಥ ಉಪನ್ಯಾಸಗಳನ್ನ ಏರ್ಪಡಿಸಿರ್ತಕ್ಕಂಥ ಟ್ರಸ್ಟ್ ನ ಎಲ್ಲಾ ಪದಾಧಿಕಾರಿಗಳೇ ಹಾಗೂ ಇವತ್ತಿನ ಈ ಉಪನ್ಯಾಸ ಮಾಲೆಯಲ್ಲಿ ಹಾಜರಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ನ್ಯಾಯಾಧೀಶರೇ, ನ್ಯಾಯವಾದಿಗಳೇ, ವಿದ್ಯಾರ್ಥಿಗಳೇ ಹಾಗೂ ಪ್ರಾಧ್ಯಾಪಕರೇ, ಎಲ್ಲ ಆಹ್ವಾನಿತರೇ, ಇವತ್ತು ನಿಜಕ್ಕೂ ಕೂಡ the discourse given by our Honorable Justice R.D. Huddar is really worth remembering forever. I, being the Vice Chancellor of the Karnataka State University, Law University, I take the advice given by our Justice R.D. Huddar to build a good career to our students and also to provide a good inputs to our students, especially in the course of their study. We have been providing the skills of debate, skills of understanding the subject, skills of even discussing the various legal issues in the colleges as well as in the universities. Sir, as you said, we have been promoting our students and we have been insisting our students to see that they should first read the textbooks, read the judgments, read the reports, original judgments, original reports, and a very authoritative textbooks on various legal issues. And that is how our students can build their real skills and talents and also art of presentation before the honorable judges. Today's discourse, in fact, is a really a commendable and thought-provoking lecture given by our Honorable Justice R.D. Huddar. That too, how the women population in India, they suffered a lot in not enjoying the property rights long back. And the way in which the status of women was discussed elaborately. I need not go because our justice has already very comprehensively discussed everything, starting from medieval era, then ancient period, how patriarchal age in which there was a total domination of the male in a family, and various earlier legislations which denied the right to property to women. For example, Hindu, as a result of which, in order to bring reformation to the women interest, many legislations were also discussed, such as Hindu Widows Remarriage Act, Hindu Women Right Property Act, and more than that, Hindu Succession Act of 1956, and in which provides a stability to our women and also provide a right over the property vis-a-vis the men. And of course, our justice was also in fact referring the constitutional rights, the fundamental rights which are guaranteed to all citizens, including our women, and where there shall not be any discrimination on the ground of sex, even in the partition of property or even in the succession to the property. And of course, many states legislations were also in fact discussed by our Honorable Justice. And much more than that, the amendment Hindu Succession Act 2005 was very comprehensively discussed threadbare by our Honorable Justice, and starting with to conceptualization of various concepts within the Hindu Succession Act. Our Justice has discussed about the joint Hindu family, the concept of joint Hindu family, the concept of copersonary, even the rule of 4 degrees. In every copersonary, there must be ancestors to the 4 grades. And also, property defined under the Hindu law was also very comprehensively discussed. And succession to the property, how the succession to the property takes place, either intestate succession or testamentary succession, was very much really comprehensively it was discussed. And sir, really today's your discourse on all these minute even issues relating to the property, especially the joint family property, then the co-personate property. And of course, we had never, in fact, thought of such a very sensitive issues involved in the co-personate property. And of course, as a result of your discourse today, you have highlighted and you opened the minds of all the legal fraternity to understand the intricacies of the co-personate property within the Hindu Succession Act 2005, and also the consequences of the amendments made to the Hindu Succession Act. And of course, as a result of which today, the women are also in fact entitled equally the property rights vis-a-vis other men. And of course, that is a positive approach towards the protection of the interest of women folk in this country, and especially under the Hindu Succession Act. Sir, for your discourse, a wonderful discourse you have given, and it has opened the eyes of all our legal fraternity, including our students. We always take in a positive spirit whatever the advice you have made to our students, our teachers, and also our advocates, lawyer advocates, practicing advocates, to read the original text. Sir, we have been insisting even in the universities to our students right from the first semester that they should read the original text so that you can understand the various concepts, and you can also understand the various doctrines and principles and precepts which are hidden in the Hindu Succession Act and especially in the Hindu law. Sir, I take this opportunity to to thank our organizers for organizing such a program, that too inviting such a great our honorable justice to give such a comprehensive discourse to all of us, which really in fact never forgotten by any of us. And I take this opportunity to thank all the organizers of this Pratisthana. And once again, I thank all the invitees and who have joined through online into this today's discourse. And I thank one and all who have participated in this program. Thank you so much.
Thank you.
ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನ ಅಲಂಕರಿಸಿ ಅಧ್ಯಕ್ಷೀಯ ನುಡಿಮುತ್ತುಗಳನ್ನು ಆಡಿದ ಮಾನ್ಯ ಡಾಕ್ಟರ್ ಸಿ ಬಸವರಾಜು, ಆನರಬಲ್ ವೈಸ್ ಚಾನ್ಸಲರ್, ಕರ್ನಾಟಕ ರಾಜ್ಯ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯ, ಅವರಿಗೆ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳು. ಕಾರ್ಯಕ್ರಮದ ವಂದನಾರ್ಪಣೆ ಮಾಡಲು ನಮ್ಮ ಪ್ರತಿಷ್ಠಾನದ ವಿಶ್ವಸ್ತರಾದ ಶ್ರೀ ಎಸ್.ಸಿ. ಪಾಟೀಲ್ ರವರನ್ನು ಆಮಂತ್ರಿಸುತ್ತೇನೆ.
ಸರ್ ನಮಸ್ಕಾರ. ವಂದನಾರ್ಪಣೆಗೆ ಮುಂಚೆ ಒಂದು ಪ್ರಕಟಣೆ. ಇದೇ ರೀತಿ ಉಪನ್ಯಾಸಗಳು 3 ಮತ್ತು 7ನೇ ತಾರೀಕು ಇರುತ್ತೆ. ಇವತ್ತು ಪಾಂಡಿತ್ಯಪೂರ್ಣ ಉಪನ್ಯಾಸ ನೀಡಿದಂತ ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದಂತ ಹುದ್ದಾರ್ ಸರ್ ಅವರಿಗೆ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳು. ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಅಪ್ಲೈಡ್ ಸೈನ್ಸ್ ಮತ್ತು ಪ್ಯೂರ್ ಸೈನ್ಸ್ ಅನ್ನ ಒಟ್ಟಿಗೆ ಸೇರಿಸಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತಾ ಇದೆ. ಪ್ಯೂರ್ ಸೈನ್ಸ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಆಗಿ ಮಾನ್ಯ ಉಪಕುಲಪತಿಗಳು, ಅಪ್ಲೈಡ್ ಸೈನ್ಸ್ ರಿಪ್ರೆಸೆಂಟೇಟಿವ್ ಆಗಿ ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರು ಬಂದಿದ್ದಾರೆ. ಸೊ ಡಿವಿಜಿಯರ್ ಹೇಳಿದಾಗೆ ಹೊಸ ಚಿಗುರು ಹಳೆ ಬೇರು ಎರಡು ಸೇರಿದಾಗ ಇದಾಗುತ್ತೆ. ಅದೇ ರೀತಿ ಪ್ರಯತ್ನ ಪ್ರತಿಷ್ಠಾನ ಮಾಡ್ತಾ ಇದೆ. ನಿಮ್ಮ ಆಶೀರ್ವಾದ ಪ್ರತಿಷ್ಠಾನಕ್ಕೆ ಇರಬೇಕು ಸರ್. ನಿಮ್ಮ ಪ್ರೆಸೆನ್ಸ್ ನಮಗೆ ಹೆಮ್ಮೆ. ಮುಂದೆ ತಾವು ನೀಡ್ತಕ್ಕಂಥ ಉಪನ್ಯಾಸಗಳನ್ನ ಮುಂಬರುವ ದಿನಗಳಲ್ಲಿ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಪಾಸ್ ಆನ್ ಮಾಡ್ಲಿಕ್ಕೆ ತಮ್ಮ ಪಾಂಡಿತ್ಯಪೂರ್ಣ ಉಪನ್ಯಾಸವನ್ನ ತಗೋತೀವಿ. ಈ ಉಪನ್ಯಾಸ ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ನಾವು ಪೋಸ್ಟ್ ಮಾಡಿರ್ತೀವಿ. ಧನ್ಯವಾದಗಳು ಸರ್. ಇನ್ನೊಂದು ಪ್ರಕಟಣೆ ಅಂದ್ರೆ ಆಗಸ್ಟ್ 12ನೇ ತಾರೀಕು ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ಮತ್ತು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದೊಂದಿಗೆ ವಿಜ್ಞಾನೇಶ್ವರ ಅಪ್ಲೈಡ್ ಸೈನ್ಸ್ ಆಫ್ ಭಾರತೀಯ ಜುರಿಸ್ಪ್ರುಡೆನ್ಸ್ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ನ್ಯಾಷನಲ್ ಕಾನ್ಫರೆನ್ಸ್ ಆಗೋದಿದೆ. ಅದಕ್ಕೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ ವಿಶ್ರಾಂತ ನ್ಯಾಯಾಧೀಶರಾದಂತ ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿ ಜಸ್ಟಿಸ್ ನಜೀರ್ ಅವರು ಬರ್ತಾ ಇದ್ದಾರೆ. ಅವರು ಪ್ರೆಸೆಂಟ್ ಗವರ್ನರ್ ಆಫ್ ಆಂಧ್ರ ಪ್ರದೇಶ್ ಇದ್ದಾರೆ. ಹಾಗೆ ಸನ್ಮಾನ್ಯ ಹೈಕೋರ್ಟ್ ನ ಉಚ್ಚ ನ್ಯಾಯಾಧೀಶರಂತ ನ್ಯಾಯಮೂರ್ತಿ ಶ್ರೀಶಾನಂದ್ರ ಬರ್ತಾ ಇದ್ದಾರೆ. ಹಾಗೆ ಚೆನ್ನೈಯಿಂದ, ಸಂಸ್ಕೃತ ವಿಶ್ವವಿದ್ಯಾಲಯದಿಂದ, ದರಭಂಗದಿಂದ ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳೆಲ್ಲ ಭಾಗವಹಿಸ್ತಾ ಇದ್ದಾರೆ. ಅದನ್ನ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ, ಪಾರ್ಟಿಸಿಪೆಂಟ್ಗೆ ನಾನು ತಿಳಿಸ್ಲಿಕ್ಕೆ ಇಚ್ಛೆ ಪಡ್ತೇನೆ. ಇವತ್ತು ಯಾರು ಆಸಕ್ತರು ಸೇರಿದ್ದಾರೆ ಅವರೆಲ್ಲರೂ ತಮ್ಮ ಆಸಕ್ತಿ ಜೊತೆ ತಮ್ಮ ಗೆಳೆಯರನ್ನ ಸೇರಿಸಿದರೆ ಇದಕ್ಕೆ ಇನ್ನೂ ಉತ್ಸಾಹ ಬರುತ್ತೆ. ಆಡ್ ಒನ್ ಅಂತೇಳಿ ಅಂತಕ್ಕಂಥ ರಿಕ್ವೆಸ್ಟ್ ಒಂದಿಗೆ ನನ್ನ ಪ್ರಕಟಣೆಯನ್ನ ಮುಗಿಸ್ತೇನೆ. ಧನ್ಯವಾದಗಳು.
ಅಮಿತ್ ಸರ್ ನಮಸ್ತೆ ಸರ್. ಸರ್ ನಾನು ವಸುಂಧರಾ ಪಾಟೀಲ್ ಅಂತ ರಾಯಚೂರು SAB ಲಾ ಕಾಲೇಜಿಂದ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ ಸರ್. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ತುಂಬಾ ಧನ್ಯವಾದಗಳು ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ಅವರಿಗೆ. ನಾನು ಹಿಂದೂ ಲಾ ಫ್ಯಾಕಲ್ಟಿ ಆಗಿರೋದ್ರಿಂದ ಇಷ್ಟು ಮೈನ್ಯೂಟ್ ಆಗಿ ವಿತಿನ್ ಒಂದು ಶಾರ್ಟ್ ಸ್ಪ್ಯಾನ್ ಆಫ್ ಟೈಮ್ ತುಂಬಾ ಚೆನ್ನಾಗಿ ಹೇಳಿದ್ರಿ ಸರ್. ಒಂದೇ ಒಂದು ನನ್ನ ಕ್ವಶನ್, ಮೇ ಬಿ ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಮೇ ನಾಟ್ ಪಾಸಿಬಲ್, ಬಟ್ ಒಂದು ಏನಂದ್ರೆ ಅದು ಡೇಟ್ಸ್ ವೈಸ್ ತಾವ್ ಹೇಳಿದ್ರಿ ಸರ್. ಅದು 2005 ಅಮೆಂಡ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಡೇಟ್ ಅಲ್ಲಿ ಸ್ಟೂಡೆಂಟ್ಸ್ ತುಂಬಾ ಕ್ವಶನ್ಸ್ ಕೇಳ್ತಾ ಇರ್ತಾರೆ. ಬೈ ಬರ್ತ್ ಇಟ್ ಸೆಲ್ಫ್ ದ ವಿಮೆನ್ ಅಕ್ವೈರ್ ದ ಕೋಪರ್ಸನರಿ ರೈಟ್ಸ್ ಅಂತ. ಅದು ಅಂದ್ರೆ ಇದು ಓವರ್ಲೋಡೆಡ್ ಆಗಿದೆ ಕೇಸಸ್ ಅಂತ. ಒಂಚೂರ್ ಅದ್ರ ಬಗ್ಗೆ ಹೈಲೈಟ್ ಮಾಡಿದ್ರೆ ಇನ್ನೂ ಚೆನ್ನಾಗಿರ್ತಿತ್ತು ಅನ್ಕೊಂಡಿದೀನಿ ಸರ್. ಅಮಿತ್ ಸರ್ ಪ್ಲೀಸ್ ಸರ್.
ಅದಕ್ಕೆ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has used the word retroactive. ಈ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ದಿ ಸಕ್ಸೆಷನ್ ಆಕ್ಟ್ ಈಸ್ ನಾಟ್ ರಿಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಆರ್ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್, ಇಟ್ ಇಸ್ ರಿಟ್ರೋಆಕ್ಟಿವ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದನ್ನ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಅವರು ಕ್ಲಾರಿಫೈ ಮಾಡ್ತಾರೆ. ಇಟ್ ಇಸ್ ಅ ಜಜ್ಮೆಂಟ್ ಆಫ್ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ BV ನಾಗರತ್ನ ಅಂಡ್ ಸೂರಜ್ ಗೋವಿಂದರಾಜ್, ರಿಪೋರ್ಟೆಡ್ ಇನ್ ILR 2020 ಕರ್ನಾಟಕ ಪೇಜ್ 2697. ILR 2020 ಕರ್ನಾಟಕ ಪೇಜ್ 2697 ನಲ್ಲಿ ಕ್ಲಾರಿಫೈ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, ವೆದರ್ ದಿ ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ ಟು ಹಿಂದೂ ಸಕ್ಸೆಷನ್ ಆಕ್ಟ್ 1956 in terms of section 6A, 6C would apply from 3794 to 89/2005 in of the ratio laid down in Prakash versus Pulavati case ಅಲ್ಲಿ. ಅದಕ್ಕೆ the Honorable High Court says The amendment by way of Karnataka Act came into force with effect from 37/1994. As such, any succession post 37/1994 in the state of Karnataka would be governed by Hindu Succession Act as amended by Karnataka Amendment. It is the amended provision which was applicable in Karnataka till the Parliament amended Hindu Succession Act 2005. The said amendment coming into force in the 2005 with effect from 9/9/2005. Any of the coming into force of the Central Amendment Act, there was some divergence of judicial opinions as to the applicability of the state amendment, the period to which it is applicable, and from the period when the Central Amendment enactment would come into force. Further held, the Karnataka Amendment Act, in terms of Section 6A, 6E would apply from 37/1994 to 8/9/2005. In view of racial and Prakash Kulwati case, from 2/9/2005, the applicability being predicated on when succession opens and availability of the property lies for partition, they are neither partitioned nor sold by way of registered instrument ಅಂತ ಹೇಳ್ತಾರೆ. So if you read this judgment, ಈಗ ಯಾವುದೇ ಒಂದು ವ್ಯಾಜ್ಯದಲ್ಲಿ ಯಾವಾಗ ಸಕ್ಸೆಷನ್ ಓಪನ್ ಆಗ್ತದೆ ಅಂತ ನೋಡ್ಬೇಕಾಗತ್ತೆ. ಅದು ಅಪ್ ಟು 2005 ಆಸ್ ಐ ಟೋಲ್ಡ್, ಅದಕ್ಕೆ ನಾನು ಮೊದಲೇ ಹೇಳಿದೆ ಡೇಟ್ಸ್ ಆರ್ ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. 1956 ಇಂದ 19 ತನಕ ಯಾವುದು, 19 ಇಂದ 1994 ತನಕ ಯಾವುದು, ಆಮೇಲೆ 2005 ತನಕ ಯಾವುದು ಅಂತ ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ಅವಾಗ ನಾವು ನೋಡ್ಬೇಕು ಯಾವಾಗ ಸಕ್ಸೆಷನ್ ಓಪನ್ ಆಗುತ್ತೆ, ಯಾವಾಗ ಇದಾಗುತ್ತೆ, ಆ ಕಾನೂನು ಹಾಕ್ಲಾಗುತ್ತೆ. ಅಪ್ ಟು 1994 ಯು ಕ್ಯಾನ್ ಅಪ್ಲೈ ದ 1990 ಜಜ್ಮೆಂಟ್, 1990 Amendment Act. From 2005 onwards, you have to apply the present Central Act. This is what the concept of the what the judgment says. So, adike I request you to read the judgment. You note down the citation ILR 2020 Karnataka page 269. So, it is a very lengthy judgment. Each and everything, every aspect have been decided, have been discussed in the judgment with regard to the interpretation of 1990 Act as well as 2005 Act, even 1956 Act. Please read this. ಅವಾಗ ನೋಡ್ಬೇಕು ನಾವು ಯಾವ ಅಪ್ಲಿಕೇಬಲ್ ಆಗುತ್ತೆ ಅಂತ. ಅಂದ್ರೆ ಅದು ಇಟ್ ಡಿಪೆಂಡ್ಸ್ ಅಪಾನ್ ದ ಪ್ಲೀಡಿಂಗ್ಸ್ ಆಫ್ ದ ಪಾರ್ಟೀಸ್. ಆ ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ಯಾವ ತರ ಇರ್ತದೆ ಅದನ್ನ ನಾವು ಹ್ಯಾವ್ ಟು ಅನಲೈಸ್, ದೆನ್ ಅಪ್ಲೈ ದಿ ಪ್ರಾಪರ್ ಲಾ.
Thank you, sir. Thank you so much.
ಎಸ್.ಸಿ. ಪಾಟೀಲ್.
ಧನ್ಯವಾದ. ಈಗ ಕೊನೆ ಘಟ್ಟಕ್ಕೆ ಬಂದು ಮುಟ್ಟಿದ್ದೀವಿ. ಅದು ವಂದನಾರ್ಪಣೆ. ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರು, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ, ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ವತಿಯಿಂದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ರಾಮ ಅವರ 93ನೇ ಹುಟ್ಟುಹಬ್ಬವನ್ನು ಆನ್ಲೈನ್ ನಲ್ಲಿ ಸರಣಿ ಉಪನ್ಯಾಸಗಳ ಮಾಲಿಕೆಯಲ್ಲಿ 3ನೇ ದಿನದ ಉಪನ್ಯಾಸ ನೀಡಲು ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಧೀಶರಾದ ಶ್ರೀ ಆರ್ ಡಿ ಹುದ್ದಾರ್ ಅವರು ಮತ್ತು ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷತೆ ವಹಿಸಿರುವ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಉಪಕುಲಪತಿಗಳಾದ ಪ್ರೊಫೆಸರ್ ಸಿ ಬಸವರಾಜು ಅವರಿಗೂ ಹೃದಯಪೂರ್ವಕ ಧನ್ಯವಾದಗಳು. ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ, ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಕುಲಪತಿಗಳು, ಉಪನ್ಯಾಸಕರು ಹಾಗೂ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳು. ಅನ್ಯಾನ್ಯ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಮಾನ್ಯ ಉಪಕುಲಪತಿಗಳವರಿಗೆ, ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಅಂತರ್ಗತ ಬರುವ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯಗಳ ಮತ್ತು ಅನ್ಯಾನ್ಯ ಮಹಾವಿದ್ಯಾಲಯಗಳ ಪ್ರಾಚಾರ್ಯರು, ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳು. ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರು ಹಾಗೂ ನ್ಯಾಯವಾದಿಗಳು ಪ್ರೊಫೆಸರ್ ಬಸವರಾಜ್ ಕೂಬಾಕಡ್ಡಿ, ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಲಬುರಗಿ, ಅದೇ ರೀತಿ CUK ಸಂಶೋಧನಾ ವಿದ್ಯಾರ್ಥಿಗಳಾದ ಶ್ರೀ ಕೃಷ್ಣ ಮತ್ತು ರಾಗಿಣಿ ಅವರು, ಅನ್ಯಾನ್ಯ ರಾಜ್ಯದಿಂದ ಭಾಗವಹಿಸಿದ ಎಲ್ಲರಿಗೂ, ಮತ್ತೆ ಸ್ವಾಗತ ಮಾಡಿದ ಶ್ರೀ ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ, ವಿಶ್ವಸ್ತರು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ, ಮತ್ತೆ ಪರಿಚಯ ಮಾಡಿದ ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ ಎಸ್ ಚಂದ್ರಶೇಖರ್, ಪ್ರಾಂಶುಪಾಲರು ಸಿದ್ಧಾರ್ಥ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯ ಕಲಬುರಗಿ, ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ವಿಶ್ವಸ್ತರೆಲ್ಲರಿಗೂ ಮತ್ತೊಮ್ಮೆ ಉಪನ್ಯಾಸ ಯಶಸ್ವಿಯಾಗಿ ಪ್ರತ್ಯಕ್ಷ ಮತ್ತು ಪರೋಕ್ಷವಾಗಿ ಸಹಕರಿಸಿದ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ನಮಸ್ಕಾರ.
ಥ್ಯಾಂಕ್ ಯು ಆಲ್.
Thank you,
ಸರ್
sir.
ನಮಸ್ತೆ. ಥ್ಯಾಂಕ್ ಯು. ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು ಸರ್.
ಸರ್ ಧನ್ಯವಾದಗಳು ಎಲ್ಲರಿಗೂ. ನಮಸ್ತೆ.